out. I keep getting flashes from the computer, so it's a little disconcerting. I'm going to say, unless that there is a stipulation as to recording either video or audio between the teams, then there will be no such video or audio taping, and I'll put you on your honor to do that. Once we get started, we're going to go straight through with a couple of exceptions. The exceptions being if there's a health emergency, then I want you to inform me of that emergency immediately, and we'll try to take care of it. The other thing is that as a matter of practice, I take a pause between each segment of the trial, meaning between the opening statement and the first witness, so that the scoring panelists have the opportunity to fill out their scorecards and then give their full attention to the proceedings before them. Scoring panelists, when you have completed filling out your scorecard for that round, please let me know either visually or by audio, and we can keep going. As the teams know, if there are any disputes regarding the rules on this competition, they must be reported to the central office for resolution by them, unless I can handle it inside the courtroom. Now I have two timekeepers for the teams. Is that true?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. How are you going to let people know about the time?
I'm going to just post it in the chat.
Okay.
I'm also just going to post it in the chat, Your Honor.
All right.
If
then.
the other timekeeper, sorry, Your Honor. If the other timekeeper wants after each witness, we can confer times just to make sure that there's not a time discrepancy.
Well, I'm going to direct that that's what happens so that we'll make sure that we're.
Okay. That would just be a direct, sorry, Your Honor. That would just be a direct message between me and the timekeeper, and we will let you know if there is one over 60 seconds.
All right. Thank you.
You're welcome.
At this time, I would like the teams to introduce the lawyers and the prospective witnesses. Turn on your cameras and go, starting with team Michael, who I believe is the plaintiff in this matter.
Your Honor, opposing counsel, and members of the jury. My name is Aisha Hollebeck, and I'll be providing the closing statement of the plaintiff, the cross-examination of Blake Doncourt, and the direct examination of Dakota Weirs. My witness would now like to introduce herself.
I think we're going to have the rest of the lawyers team introduce themselves. Jada, you're a witness. Who are the other lawyers on team Michael?
One moment, Your Honor. Experiencing technical difficulties.
Okay. If you're experiencing technical difficulties, let me know, and we're not going to have that count against your time during the competition.
Your Honor, opposing counsel and members of the jury, my name is Christopher Cooper, and I'll be providing the opening statement for the plaintiff, conducting the cross-examination of Skylar Weirs, and the direct examination of Carson Durst. My co-counsel will introduce herself.
Your Honor, opposing counsel and members of the jury, my name is Sydney Pavetti, and I will be conducting the cross-examination of Dr. Devin Williams and the direct examination of Casey Rogers. At this time, our witnesses would now like to introduce themselves.
Please go forward.
Your Honor, my name is Jada Askew, and I am Dakota Weirs.
Thank you.
Your Honor, my name is Alyssa Springs Pena, and I am Carson Durst.
Thank you.
Your Honor, my name is Sierra Bourne, and I am Dr. Casey Rogers.
Thank you. All right, Team Toby, please have your attorneys introduce themselves.
Your Honor, members of the jury, and opposing counsel. My name is Elwood Shefflin. Today, I'll be performing our pretrial matters, as well as the cross-examination of Dr. Casey Rogers and the direct examination of Dr. Devin Williams. My co-counsel would like to introduce themselves.
Please go forward.
Good afternoon, Your Honor. My name is Sierra Bono, and I will be performing the opening statement, the cross-examination of Dakota Wires, and the direct examination of Skylar Wires.
Thank you.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Abby Miller, and I'll be conducting the direct examination of Blake Doncourt, the cross-examination of Carson Durst, as well as our closing argument. May our witnesses please introduce themselves?
Please do.
Thank you. Good afternoon. My name is Ellie Hoffman, and I am Dr. Devin Williams.
Good afternoon. I am Curtis Anderson, and I will be playing Skylar Wires.
Thank you.
Good afternoon. My name is Layla Reyes, and I will be playing the role of Blake Doncourt.
Thank you. At this time, to emphasize the importance of playing by the rules in this competition and adhering to your statements, I'm going to ask both teams to be sworn in. So all team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? All right, thank you. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? All right, thank you. Scoring panelists, please raise your right hands. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes, Your Honor.
All right, thank you. Now, are there any pretrial matters that the teams want to bring before the court?
Yes, Your Honor.
Okay,
Your Honor, we would like the record to reflect that the trial rosters have been shared, I think, in the chat before I was entered into the room.
they have been, yes.
Your Honor, we would also like the record to reflect that the stipulations agreed to by the parties are already part of the trial record according to Rule 4.7.
They are.
Your Honor, we would like the record to reflect that opposing counsel has shared and has received all of our witness statements and exhibits for today's court.
I expect they have, but would the defense please confirm that?
We have, Your Honor.
And plaintiff, you have received all of theirs.
Yes, Your Honor.
Okay,
And finally, Your Honor, we would like to request that when entering exhibits, co-counsel share their screen while identifying them before they are so entered.
I'm sorry, would you say that again, please?
Yes, Your Honor. Before exhibits are entered, we ask that our co-counsel is allowed to share their screens. So that way the witnesses may identify what they are and explain before they are entered.
Does the defense have any objection to that?
No objection, Your Honor.
Then that will be how we proceed. Thank you.
No further preliminary matters, Your Honor.
Does the defense have any additional preliminary matters?
We do, Your Honor. We have 4 additional preliminary matters. May I
Go
begin?
ahead. Yes.
First of all, we'd like to request that the court pause the clock for any technical issues our team might experience.
As I said earlier, that's the way we're going to proceed.
We'd like to confirm that the jury has access to all of their jury instructions.
The jurors have received a case file which includes both the jury instructions, preliminary orders, and the exhibits.
Moving on, we'd like to just make sure that the court has access to all of its prior rulings on the topic.
As indicated, I have received a case file.
And then lastly, we'd just like to inform the court that, as we previously mentioned, we're all competing from the same building. That means that we have one computer for witnesses and one computer for attorneys. We'd request that we have time to change our names to reflect who is actively at that computer, just to make scoring easier for the jury.
Is there an objection to that procedure from the plaintiff?
No, Your Honor.
Then that's how we will proceed. Anything else?
That's all, Your Honor.
All right, thank you.
I can't tell if they're good or not.
Plaintiff, you can begin with your opening statement.
Yes, Your Honor. Your Honor, opposing counsel and members of the jury, how much is one life worth? That, ladies and gentlemen, is the question we are here to answer today. Dakota Weirs, the plaintiff, believes that Lush has caused her cancer. Dakota was only 14, trying to make a little bit of money working for a company called Haven Landscape, when she was exposed to Lush's products. Her life is now basically ruined now that she has developed non-Hodgkin's lymphoma. She can't do any of her favorite things, such as play the piano and be active in her community. Dakota loved playing the piano and even got a full ride scholarship to Julia. 20 years old, isn't that the age that you're supposed to feel free? Like there is no worry in the world. Now Dakota can't even go into the world and be free, let alone anything else. Members of the jury, we have what is called a burden of proof in this case. We have to prove to you that the defendant manufactured a fertilizer product containing the chemical compound known as Druf. The defendant was negligent by failing to exercise unreasonable care to prevent the product from creating an unreasonable risk of harm to people who might reasonably be expected to use the product in the manner the defendant might have reasonably expected. The plaintiff was one of those persons the defendant should have reasonably expected to use the product, and that the plaintiff had damages that were caused by the defendant's negligence while the product was being used in the manner the defendant should have reasonably expected. You'll hear many testimonies today from many different witnesses. One of them will be Dr. Casey Rogers, who ran a private study into Drufo and found a causal link between non-Hodgkin's lymphoma and Drufo exposure. Another witness you'll hear from is a former Lush scientist, Carson Durst, that found concerns around the results of the studies that Lush conducted and found that Drufo may cause non-Hodgkin's lymphoma and brought it up to the executives of Lush, and they said to sweep it under the rug. You'll also hear from Dakota Weirs herself, and she will tell you how this has impacted her life and how this disease is so terrible on her. Opposing counsel may try to convince you that Dakota was negligent in her actions. If you believe their arguments, but also believe that Lush was more negligent than Dakota, your verdict must be for the plaintiff. How much is one life worth? We believe we cannot put a price on one life. Thank you.
Thank you. The defendant may make its opening statement.
Thank you, Your Honor. Before I begin, I would like to check that timekeepers are ready.
I'm ready.
proof, not possibilities. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Sierra Bono, and I, along with Elwood Shefflin and Abby Miller, will be representing the defense. We thank you for being here today, and we ask you to look at this case through the lens of proof, not possibilities. You have already heard the plaintiff tell the story of young Dakota Wires, who is now suffering from the detrimental effects of cancer. And they have told you how she believes that Lush is at fault for this awful illness. But ladies and gentlemen, Lush is not at fault. Lush is a company that has and will always strive to keep environmental excellence. To begin today, the plaintiff will call their 3 witnesses to the stand: Dr. Casey Rogers, Carson Durst, and Dakota Wires. Dr. Casey Rogers will tell you of a study they conducted and how it shows a possible link between cancer and Drufo. But ladies and gentlemen, not only has this study not been peer-reviewed, it also hasn't been proven. Next, Carson Durst will take the stand and tell you that while working at the short time as an intern at Lush, they found a possible study that showed a link between carcinogens within Drufo and rats. But yet again, this study has not been proven. But they will also tell you about a proven study within Lush that showed that Drufo was as safe, if not safer, than the government recommends. Finally, Dakota Wires will take the stand and tell you that while working at Haven Landscaping, they chose not to wear the correct protective gear that was recommended by both their boss and Lush Fertilizer. They will also tell you that they have no idea what caused their cancer. Lush causing it is just a possibility. Ladies and gentlemen, the plaintiff's case is all based on possibilities, possible studies, possible causes, and possible risks. We, the defense, ask you to listen in to the plaintiff witness's testimony today and hear all the times they use words like I think, maybe, could, possibly. Next, we, the defense, will take the stand and tell you about Lush Fertilizer. We will call Dr. Devin Williams, Skylar Wires, and Blake Doncourt to the stand. Dr. Devin Williams will tell you that the research and the data shows that Drufo is a safe product, and that the studies, including Casey Rogers against Drufo, only have possibilities. Next, Skylar Wires will take the stand and tell you how Drufo has proven benefits. Not only is Drufo amazing for our environment, it is also amazing for its users. They will also tell you more about Dakota's work at Lush and all the other harmful fertilizers and chemicals they used. Finally, Blake Doncourt will take the stand and tell you how she built her company from the ground up, and how it has and will always strive for environmental excellence, and how she never would have put a product on the market that would have hurt her users. We, the defense, will show you proven, inconclusive proof. Proven environmentalists, proven benefits, and proven studies. We, the defense, ask you to see the proof behind the claims and studies that we will provide, and look past all of the possibilities provided by the plaintiff, and you will see that Lush Fertilizer is not negligent. Thank you.
Thank you.
I'm ready, Your Honor.
Ready, Your Honor.
Holly?
She's giving you a thumbs up.
Oh, okay. Thank you. Plaintiff, you may call your first witness.
Thank you, Your Honor. At this time, we call Dakota Weirs to the stand.
I'll remind the witness that the oath taken at the beginning of this proceeding remains in effect.
Hi, Dakota. I know this will be hard for you, so if at any point you need to take a break, let me know. Please state your name and spelling the last for record.
Dakota Weirs, Weirs.
How old are you?
I am 20 years old.
What do you do for a living?
Nothing?
Do you have a job?
No, I do not.
Why not?
Well, due to my condition, I can no longer function in society properly.
Why are you here today, Ms. Weirs?
I'm suing Lush Fertilizer because their products gave me cancer.
Why do you believe Lush Fertilizer is responsible for this?
When I was 14 years old, I worked at Haven's Landscaping, and I was responsible for fertilizer. And the main fertilizers I used was Lush Fertilizer, which contains Drufo.
Okay, now let's talk a little bit about Drufo. Where did you use this product?
I often use this product in large office buildings, usually in the lobbies.
How did you find out about Drufo?
There was a story about Lush Fertilizer's main ingredient, which is Drufo.
Objection, Your Honor.
What's your objection?
This is hearsay.
Ms. Hollaback?
Your Honor, this is not hearsay. It's not being offered for the truth of the matter asserted, but instead for the effect on Dakota Weirs and why she has taken the steps she has to be here today.
May I
Ms.
respond, Your Honor?
Ms. Bono?
Is there for the truth of the matter asserted because it is here to prove the truth that Drufo might have caused Dakota's cancer.
Well, what I heard the question to be was what led the witness to start to investigate Drufo, and that to me is something that is asking a question about what effect a news story had on her. Therefore, the objection is overruled. Ms. Hollaback, go ahead.
Your Honor, let the record reflect my co-counsel is sharing on their screen a copy of what has been pre-marked as Exhibit 1.
Okay.
A moment while my co-counsel brings up that document.
I think it's up.
Would you please identify the document on the screen, Ms. Weirs?
Yes, this is an accurate description of Lush Fertilizer, just as I remember it.
Is this document the type of label you saw while working at Haven Landscaping?
Yes.
Is this document true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I move for the admission of Exhibit 1. Its authenticity has been stipulated to and its accuracy shown.
Is there an objection to the admission of Exhibit 1?
Yes, Your Honor. I have the objection of lack of foundation. That my opposing party hasn't stated how Ms. Weirs got this label or how they got this label and how they, besides that they worked with it, if they know anything else about it and how they know about it.
Ms. Hollaback?
Your Honor, I do believe I laid the proper foundation. I believe one of my questions, my witness answered that she had worked since 14 years old at Haven Landscaping, and that during her time, she used Lush Fertilizers products, which contain Trufo, and this is a Lush Fertilizer label that she used, which she has already.
May I respond, Your Honor?
Yes.
They still haven't testified to how Miss Wires got this label and how she knows that is exactly the label that she used during her time, besides that she happens to recognize it.
Well, the authenticity is not at issue. She testified that she worked for a period of time and that she recognized the label as the label on the fertilizer used. I think that's adequate to admit it into evidence, and therefore the objection is overruled. Go ahead, Ms. Albrecht.
Sorry, my apologies. What is depicted on the Lush Fertilizer label, Dakota?
It shows the ingredients of Lush fertilizer, but no warnings.
Why is no warning label on the fertilizer packaging important to you?
Well, when you have certain warnings, you can take certain precautions. I thought that's what labels were for.
Why do you believe that your illness was not caused by other environmental factors?
Well, I have a twin, and we basically participate in everything. Besides that, I worked at Haven's Landscaping, and my twin did not. But had she worked at Haven's Landscaping with me, she would have gotten the same condition that I had.
Now let's talk a little bit about your time at Haven Landscaping. Were there any safety recommendations in place at Haven?
There was, yes.
What were these safety recommendations?
I mean, my boss technically told us to wear long sleeves, long pants, and gloves.
Were these safety recommendations ever enforced?
No, they were not. These were recommended.
Did you follow all of the safety recommendations?
At times I did, but most of the time I did not.
And why did you not follow all of them?
Well, I was 14 years old and it was hot outside, and my other co-workers weren't wearing their protective gear, clothing. And being 14, I just followed along with the crowd.
Now let's talk a little bit about your non-Hodgkin's lymphoma. What is non-Hodgkin's lymphoma?
It is a cancer.
What are your symptoms?
Well, I have extremely painful lymph nodes. I have frequent weight loss. I get chills. They're horrible.
Is there a cure for this cancer?
Unfortunately, there isn't.
Now let's talk a little bit about the impact this condition has had on you. How has non-Hodgkin's lymphoma affected you?
Ever since I was young, I loved to play the piano, and this brought me closer to my grandfather. But now that I have this condition, I can no longer do the things that I love. I love to play the community, and I love to help others in need. But I can't function properly now with my cancer.
Has non-Hodgkin's lymphoma had a financial impact on you?
Of course it has. My father has to pay extremely.
Your Honor. May I would you
What
like?
is your objection?
Relevance. Ms. Wires is not asking for any compensation for financial damages in this case, so I believe this is not relevant to this case.
Ms. Hollaback?
Your Honor, this response deals with the damages the plaintiff has accumulated that is non-economic, as it has had emotional damages on her.
May I respond, Your Honor?
Yes, you may.
This question is specifically about financial damages that Dakota Wires has accumulated, which is not at all non-economic. It is specifically economic, and it's not at all based on the emotional damages Dakota has experienced from receiving non-Hodgkin's lymphoma.
Well, I understood the question to ask about her ability to earn money. Is that inaccurate, Ms. Hollaback?
Your Honor, if you'd like, I can rephrase the question.
Please do.
Dakota, has non-Hodgkin's lymphoma had an emotional impact on you?
Of course it has. Like I said, I love to play the piano, and because I gotten so well at it, I had a scholarship at Juilliard. But now that I have cancer, I can no longer participate in a scholarship.
Dakota, if you feel comfortable enough to answer, how much is your life worth to you?
I feel like my life is worth so much, if I may say so, more than others. Because of my condition, I can't do anything that I love. And any 20-year-old wants to go out and be with their friends and go to parties and do things that 20-year-olds do, but I can no longer do that.
And then just one more question. What do you hope to accomplish in suing Lush Fertilizer?
Well, I would love to not anybody to get this condition, this cancer that I have. But if I am compensated for what I've gone through, I would love to donate to the finding of the cure of non-Hodgkin's lymphoma.
Thank you, Ms. Weirs. No further questions, Your Honor.
Thank you. Ms. Bono, you have cross-examination?
Yes, Your Honor. Before I begin, I'd like to check that my timekeepers are ready. Now, you started working at 14.
I did, yes.
At Haven Landscaping,
I did, yes.
which was a small locally owned business.
Yes, it was.
And you specifically worked to spread the fertilizer at this job.
Yes, I did.
And during that time, and you worked there for about 4 years.
Yes.
And during that time, you were never fired.
No, I wasn't.
And you were a pretty good employee.
Yes, I was.
And as you mentioned, your boss had some things that he told you that you should do while working.
I'm sorry, the computer broke up. Can you rephrase the question?
Of course. While working at Haven, your boss told you a few things that you should do while working.
Yes, they did.
And one of these things was that you should wear a mask.
Yes.
But you did not.
No, I did not.
And you were also told that you should wear long sleeves.
Yes.
But you did not.
Sometimes I didn't.
And you were also told to wear long pants.
It was recommended.
But you did not.
No.
And you were also told that you were supposed to wear gloves.
Yes.
But you did not.
No, I did not.
And you were told to wear these gloves because, as mentioned, you were spreading the fertilizer with your hands.
Yes, I did.
And let's talk a little bit about that label that was brought into evidence a little bit ago. You decided to contact your boss about this label after you saw this news article.
I did, yes.
And after seeing this news article, you realized, oh my gosh, I worked with Lush.
Yes.
And so after that, you contacted your boss and he provided you with an old label from Lush Fertilizer.
Yes.
But this label had no date on it.
No, it did not.
Your Honor, I'm requesting co-counsel to screen share Exhibit 1. Now, Ms. Weirs, do you see the area that's labeled user safety recommendations in all caps?
Yes.
I'm going to ask you to read along silently while I read aloud. Utilize protective clothing that covers exposed skin. Did I read that correctly?
Yes, you did.
But you did not.
Sometimes.
And it also
Most
says,
of the time I did.
and it also says use of a respirator or N95 mask is recommended.
Yes.
But you did not wear either of those.
No, I did not.
Thank you. Co-counsel, you can now stop screen sharing. Now, Ms. Wires, let's talk a little bit more about your work at Haven Landscaping. While working at Haven, you had used other products besides Lush,
Yes, I did use other fertilizers.
and you also used other chemicals.
Objection
Yes.
relevant.
The objection is relevant. Ms. Bono, do you have a response?
This is extremely relevant to the case because this is showing the other harmful chemicals and fertilizers that Dakota may have worked with that could have also caused her non-Hodgkin's lymphoma besides Lush fertilizer.
Ms. Hollaback, isn't the question relevant to causation?
Your Honor, if I may, the other fertilizers and chemicals you use are not exactly relevant to this case, as we are trying to figure out if Drufa was the cause of her cancer, not these other fertilizers and chemicals.
But isn't part of the causation by Drufa the possibility that there is a different causal agent?
If opposing counsel could lay more foundation for that question, then I will withdraw my relevant objection.
Can I respond, Your Honor, really quickly?
I don't think you need to. I'm going to overrule the objection. Go ahead.
Would you like me to re-ask my question, Ms. Wise?
Yes, please.
While on the job, you used other fertilizers and chemicals.
I did.
And these other fertilizers and chemicals had warnings.
Yes.
And these were warnings such as that you should wear a mask,
Yes.
but you still did not wear a mask.
No, I did not.
Thank you. Now moving on a little bit to your diagnosis. You believe that Lush fertilizer caused your cancer,
Of course I did.
but you have no definitive proof that it caused your cancer.
No, I do not.
Overall, you have no idea what caused your cancer.
Unfortunately, I don't.
And but you're still suing Lush?
Yes, because it's my belief that they gave me cancer.
Exactly, it's your belief. And you are not suing any of the other fertilizers and chemicals that you used on the job.
No, I am not.
Oh, sorry, Ms. Wires. Even though you don't know what caused your cancer.
I'm sorry, can you repeat the question?
Of course, even though you don't know what caused your cancer.
Actually, no.
Thank you, Your Honor. No further questions.
Okay, thank you. Ms. Hollaback, do you have any redirect?
Yes, Your Honor. Hello, Ms. Weirs. Why did you not follow all the safety recommendations on the label?
Sometimes it was outside, and the other people that I was working with wore t-shirts and shorts, and I decided to go along. But of course, I regret this decision now, as I have cancer.
And shifting gears a little bit, why do you believe that Lush fertilizer specifically is the one that caused your cancer?
Because I use Lush.
Your Honor, improper lay opinion. This witness is not an expert in certain things that cause chemicals or toxicology, so they cannot testify to opinions on what could have caused their cancer.
What rule is it?
Ms. Hollaback?
And this is Rules of Evidence 701.
Ms. Hollaback?
Your
you
Honor. Yes, my apologies, Your Honor. According to Rules of Evidence 701, a witness is allowed to give their opinion, and I feel like in this case, Ms. Weirs, having contracted this condition and working with a Lush fertilizer, she has a right to her opinion, considering this is why we are bringing the court here today.
May I respond, Your Honor?
I don't think it's necessary. I think the question was, why do you think that Lush caused the cancer? Without an answer, I can't determine whether she's giving an opinion or if there is some other reason that she thinks that the causal agent was the Lush fertilizer. Therefore, I'll overrule the objection and we'll wait for the answer. Go ahead and re-ask the question, Ms. Hollaback.
Of course, Your Honor. Dakota, why do you believe it was Lush fertilizer who gave you cancer?
Like I said, I work with Lush Fertilizer, which contains trees for emergency time with Havens Landscaping.
No further questions, Your Honor.
All right, thank you. The witness is excused.
Your Honor, the plaintiff calls Carson Durst.
We're going to wait until the scores are done. I see
I'm
Ms.
sorry, Your
Holly,
Honor.
Ms. Ryan is done.
Ready, Your Honor.
Sorry, Your Honor.
Ready, Your Honor.
Okay, thank you. Mr. Cooper, you may go ahead and call your next witness.
We call Carson Durst to the stand, Your Honor. Please state your name, spelling the last for the record.
Carson Durst, Durst.
What do you do during the day, Carson?
Lead product developer at Terra's Greenery.
And did you have any previous jobs?
Yes, actually, I was a product engineer back at Lush Incorporated.
And to be clear to the jury, when did you Lush Fertilizer?
Can you repeat that? You completely cut out.
Oh, of course. And to be clear to the jury, when did you leave Lush Fertilizer?
Can you say that one more time?
To be clear to the jury, when did you leave Lush Fertilizer?
I actually got dismissed back in December of 2006.
And why did you choose to work for Lush Fertilizer Incorporated?
I'm sorry, you keep.
Your Honor, I'm experiencing that too. I'm not sure if it's coming through on your end, but I'm having some trouble hearing Mr. Cooper as well.
I think I agree that there's a little difficulty. I think I'm hearing him better than perhaps you folks are. But Mr. Cooper, could you try speaking up and perhaps slowing down?
Yes, Your Honor, but a moment to fix our technical issues.
Go ahead.
Is it better now?
Yes, I can hear you.
Okay, go
Okay.
ahead, Mr. Cooper.
Thank you, Your Honor. I'm going to go back. When did you, or why did you choose to work with Lush Fertilizer?
Can you repeat that last bit right there?
When did you, why did you choose to work for Lush?
Why did I choose to work for Lush?
Yes.
So I actually hadn't had a job planned out, and I had been told by a family friend who was related to the Don Courts that I could actually get some strings pulling. And shortly after that, I was able to get my application, and I put it in, and then I got the job.
So you had a family connection when entering the company?
Yes, I've known the Don Courts for a very long time. They were like a second family to me. And so it helped me get my job, but that it was as far as I went with that.
Did it help you get your internship or your real office job?
Oh, no, I'm so sorry. It helped me get my internship.
And did it help you after getting an internship?
No, I worked hard actually to get a promotion to get the real job.
Objection, Your Honor, lack of personal knowledge. In order for the witness to fully testify truthfully to this question, they would have to understand from the Don Court's point of view, if whether or not that family friend influence did actually have an impact on them moving up in the company. As Ms. Durst is only herself and not a true member of the Doncourt family, she does not have the personal knowledge to understand the full influences under which her promotion may have occurred.
Mr. Cooper?
Your Honor, this was an impression as Blake Doncourt himself told this directly to.
I'm sorry that you broke up completely on that.
Your Honor, this is present sense impression.
I'm not, again, Mr. Cooper, I'm not sure what you said.
He's muted now.
Mr. Cooper, you're muted.
This was present sense impression, Your Honor, as Blake Doncourt himself told this directly to my witness.
Your Honor, may I respond?
Yes.
Present sense impression is a hearsay exception, which is Rule 801 in the 800s. I'm objecting on the grounds of Rules of Evidence 602, lack of personal knowledge, and here hearsay exceptions do not apply.
Well, that may be, but what I heard Mr. Cooper say was that the knowledge of the witness is based upon what was told to her by one of the management teams of the Lush Corporation. So while the rule of evidence may not be directly pertinent, I think that he has established a foundation and can have the question answered, so overruled. Go ahead, Mr. Cooper.
Thank you, Your Honor. Would you like me to re-ask the question?
Yes, please.
Did your family connection help you after getting your internship?
No, all I knew was that I had put my internship in and that I had got the job. And from then on, I had continued my work and then I had gotten a promotion.
And when did you start with Lush Fertilizer?
In June of 2003.
And when you were hired, were you assigned a certain position?
Actually, yes, I was assigned on the research and development team.
And when did you become a product development engineer?
About roughly 3 months after I had started my internship.
And were you still on the toxicology research and development team when you were promoted?
Yes, I was.
And did you help on any specific projects while working at Lush?
Yes, I helped with the creation of Drufo. I helped with Drufo.
And did you know what Drufo was going to be used for?
Yes, Drufo is actually used as a bonding agent and fertilizer to help with crops.
And what was your first task related to Drufo?
What?
What was your first task related to Drufo?
I had been tasked with finding the chemical compounds that comprised in Drufo.
And what were the results of your research?
I had actually come up upon a study done in England about how it had been carcinogenic in rats.
Objection, Your Honor, facts not in evidence. This witness is testifying to conclusions which are found in a study which we have not seen yet today. If they would like to enter this as an exhibit, as I believe it's Exhibit 3, then this would not be assuming facts not in evidence, but as we have not seen this exhibit thus far, it is assuming facts not in evidence.
Mr. Cooper?
Your Honor, this is laying foundation as I am about to enter the exhibit.
Okay, then overruled. Go ahead.
Thank you, Your Honor. And did you document the finding of this article?
Yes, actually, I had documented it way back in June in my lab notebook.
Your Honor, with your permission, I request that my co-counsel share what has been pre-marked as Exhibit 3.
Please do.
Have you seen this document before?
Yes, this is the study done in England.
And when did you find this article?
Back in June of 2003.
And is it common procedure to log a finding such as this?
Yes, actually, we would log our findings in our notebooks, and we would then give them to our product manager, Gary Langley, and he would read all of our reports and make it into one final report.
And is this document true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, we move to enter Exhibit 3.
Is there an objection to the admission of Exhibit 3 into evidence?
There is, Your Honor. I object on the grounds of hearsay.
Please explain.
This document follows the definition of hearsay exactly. It is an out-of-court statement being brought in for the truth of the matter asserted and does not qualify under any of the non-hearsay rules or any of the hearsay exceptions outlined within the 800 rules in the rules of evidence.
Mr. Cooper?
Your Honor, this is hearsay, but due to the hearsay exception 8036D, this is a business record. And I can elaborate further if the court would like.
Please do.
Yes, Your Honor. So to qualify this as a business record, it has to meet 4 categories. One category is that it was made at or found at or near the time of the event. As my witness has just testified, this is relevant because of that. This was made by a person with actual knowledge. This is by a team of scientists and people like that, and found by my witness and cross-check their research.
I'm going to object on the grounds of attorney testifying here. If the plaintiff were to prove all of these things, they would have to prove them through the testimony of their witness, not through explanations by the attorney.
Miss Miller?
Mhm.
Mr. Cooper is making his argument. You'll have an opportunity to respond, so please do not interrupt him. Thank you. Mr. Cooper, proceed.
Thank you, Your Honor. 3 is that it is kept in the ordinary course of regularly conducted activity, which it was, as people at Lush would use this to cross-check their research, and it was put in my witness's lab notebook, and numerous scientists looked at it. As well as 4, it is testified to by the custodian of the record or other qualified witness, which I believe my witness has proven, as she has read and understands the article completely and has cross-checked it with other scientists and have gotten the same results.
All right, thank you. Now, Ms. Miller.
This is not does not fall under 803 subsection 6, as this is not a record of a regularly conducted activity. This is only one study that was never followed up on. There was never any regular collection of data that occurred. And so thus, it does not fall under exception 6 here, as part B has failed to be proven and parts A through E need to be proven. Part B explains to us that it must be a record of regularly conducted activity, which it is not. And so all of the elements to qualify it as such have not been proven.
Okay, well, I think that the defendant's argument regarding what would constitute a business record under the hearsay rule is probably well taken. However, there is testimony that this was collected by the witness in the course of her employment by the defendant Lush, and that part of her duties in that role were to collect this kind of information, to include it in a report or a notebook that is provided to the administration of Lush. And in that, it comes close to being a business record. And in any event, what seems to be proved by this is a notice to the corporation of a condition that they may or may not want to investigate. And as a document that would provide notice, it would be different from attempting to prove the truth of the matter asserted in the document. For that reason, I'm going to overrule the objection. You may go ahead, Mr. Cooper.
Thank you, Your Honor. What was your reaction after reading this article, Carson?
That there's a possibility it could be carcinogenic as well.
Oh, Your Honor, my apologies, but I cannot hear Ms. Durst.
I suffer the same problem. So
I'm
Ms.
having a
Durst,
technical difficulty. Can I deal with that?
yes, please do.
All right, give me a second. So sorry.
Now, is the witness going to be testifying more from this exhibit? Mr. Cooper,
I'm sorry, could you repeat that one more time?
is the witness going to be testifying more from this exhibit?
Just this question and my next question, Your Honor.
Okay. And we'll keep it up. I was just wondering if having it up disturbs the transmission of the audio.
Can you guys hear me?
Yes, that's much better for me.
All right, thank you.
May I continue, Your Honor?
Ms. Miller, can you hear the witness?
I can just fine. Thank you.
All right, thank you, Mr. Cooper. Go ahead.
Thank you. I'm going to re-ask that last question. What was your reaction after reading this article?
That if it had been carcinogenic in humans, that there was a possibility it could be carcinogenic in humans as well.
And does the article suggest that?
Yes, it has. In the last paragraph of the conclusion section, it does mention how there could be some risk and how there is to young children, ladies actually, and older women.
Thank you. I would like to ask you to define a word that you have used many times. Can you explain what carcinogenic means?
Yes, carcinogenic is a possibility to cause cancer.
All right, let's talk about your research for Lush. Did your research end after this first study?
No, it did not.
Then what happened?
I actually received an email about how we would conduct a second study into humans to see if it had been carcinogenic to them.
And were you still an intern when you started the second study?
No, I was not.
Your Honor, with your permission, I request that my co-counsel share what has been pre-marked as Exhibit 4.
Go ahead.
Have you seen this document before?
Yes, this is the email sent to me from my boss about how we would do the second study.
And who's the writer of this email?
Gary Langley.
And who is that?
He was my boss at the time.
And do you happen to remember, or does it say in the document, what time of year you received this email?
Actually, in the document, it does say that it had been sent on September 14th.
Facts not in evidence. This witness is testifying to specific details within this exhibit. And while I understand that it's in an attempt to lay foundation, they're doing it in an improper way by assuming facts not in evidence and reading directly from the exhibit before it has been entered.
I sustain the objection. Mr. Cooper, lay your foundation without reading the substance of the email.
Yes, Your Honor. Do you happen, or I will just move on. Is this document true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, we move to enter this exhibit.
Is there an objection to the admission of Exhibit 4 into evidence?
There is no admission, Your Honor, or no objection, Your Honor.
All right, then it is Exhibit 4 is admitted into evidence. Go ahead, Mr. Cooper.
What was your reaction to this email?
That there had been a bias and that they wanted to read it, that they wanted the people who read the email to read it in a specific way.
And had they told you to read test results in a certain way before?
It was not very unique of them, so yes.
And was there any concerns around the results of the second study?
Yes, there was a concern of it causing non-Hodgkin's lymphoma, which is a type of cancer.
And to be clear to the jury, the second study is what is the second study?
It's the study we conducted on humans.
Thank you. And what did your bosses say to the finding that it could be carcinogenic in humans?
To keep it in the walls and that there would
Hearsay. This is an out-of-court statement being brought in and offered for the truth of the matter asserted.
Mr. Cooper?
Your Honor, this is present sense impression and opposing party statement, as Blake Doncourt himself has told my witness these in person.
Ms. Miller?
Your Honor, this does not apply to a present sense impression, as it's not describing or explaining an event or condition, which is what present sense impression requires. And then as well, it is not opposing party statement because while it was stated by people who worked at Lush Fertilizer, there are specific requirements under 801 D2, which opposing counsel must lay foundation for to explain that it is opposing party, and A through E there have not been shown.
Well, I agree. It doesn't have much to do with a present sense impression. However, the testimony, as I understand it, this was a communication from the witness's superior and was a communication that was within the scope of the authority of the superior to a inferior or agency position. Therefore, it is a statement of a party opponent and the objection is overruled. Go ahead, Mr. Cooper.
Thank you, Your Honor. What did your bosses say to this finding that it could cause non-Hodgkin's lymphoma?
to keep it in the walls and that there would be further analysis needed.
And what does in the walls mean?
That they hadn't wanted to get out to anybody yet until they had been completely sure whether it had caused any problems or harm to the people using this product because the test had come back inconclusive.
And was there a solution to this problem?
There had been a solution to bake the product in order to cancel all risks of carcinogens.
And if you know, does Lush not bake their products?
Probably because it would, well, because it would be seen as a
Objection, Your Honor.
above and
Speculation. This qualifies as speculation because even though opposing counsel qualified, if you know, this witness does not have the ability to see into the minds of her superiors at Lush. And so she would not know why Lush did not make their products, as she was not involved in any conversations around that or any of the decision making. So thus this is speculation.
Well, we don't know what the witness knows or doesn't know. However, there has been no foundation laid for that knowledge. So there's nothing to support her testimony. Mr. Cooper, if you have foundation, you can lay it and maybe she can offer testimony. So the objection is sustained.
Yes, Your Honor. What would baking the fertilizer do?
And the odds of there being possible carcinogens in the product.
And was this suggested to the Lush?
I'm sorry,
I
suggested.
couldn't quite hear that question.
I couldn't
I'm
either.
sorry, what did you say?
Suggested to whom, Mr. Cooper?
I'm sorry. And did you suggest a solution to the executives of Lush?
Actually, we would get reports, and one of the reports we had gotten.
I'm sorry,
About how making the.
I can't hear. I could not hear what she was testifying to. Would you repeat that, please?
Me?
Yes, you.
What? What did you say?
Would you repeat your answer? I couldn't understand it.
Yes, I would. So actually reports and like reports, and one of the reports it had talked about Truffaut and how baking it with can risk of there being a possible carcinogen.
No further questions, Your Honor.
All right, thank you. Ms. Miller, cross-examination.
Yes, Your Honor. And just before I proceed, I would like to confirm that both timekeepers are ready. Okay, and as well, may I ask for a quick time check from the timekeepers?
I have 14 minutes and 55 seconds.
Thank you.
I'm going to suggest to Team Toby that we're going to assume the timekeepers are doing their jobs. And so they will be ready when you're ready to start talking. If you want a time check, ask for a time check.
Okay. Thank you, Your Honor. May I proceed?
Yes, you may.
Okay, misters, let's begin by discussing your relationship with Blake in the Dawn courts. Blake is the parent of one of your childhood best friends, yes?
Yes, he is.
And that friend is Charlie.
Yes, yes,
Okay.
it is.
And Blake Doncourt is currently the CEO of Lush Fertilizer, yes?
Yes, he is.
Okay, and you and Charles or Charlie attended university together, yes?
Yes, we did.
Objection, relevance?
Your Honor, this is relevant as it goes to bias. I am attempting to establish that Carson has a relationship to Charlie, who has a relationship to Blake Doncourt, and thus there's a string of relations between Carson and Blake. And because this has to do with them both being Lush employees, I'm just trying to lay the foundation for some bias, which misters may have.
Okay, the relevance stated is to prove potential bias by the witness, Mr. Cooper. Do you have a response?
Yes, Your Honor. I already established that she had a family connection and a relationship with Blake Doncourt on direct. And so I understand that they are laying foundation for a bias. I was just objecting so that because Charlie is not on stand and is not relevant to today's case.
Well, as you raised the issue on direct examination, I think it's certainly fair for the cross-examiner to examine that relationship further, and the objection is overruled. Go ahead, Ms. Miller.
Thank you, Your Honor. Mr. Still, go ahead and re-ask my question for you. You and Charles attended university together?
Yes, we did.
Okay, and near the end of your time at university, you found yourself looking for a job, yes?
Yes, I did.
And as of spring break of that year, you had not yet had any jobs lined up.
No, I hadn't.
So you confided in Charles.
I had to think about it.
Oh, I'm so sorry, Ms. Durst. I could not quite hear you. Could you repeat that for me?
Yes, I had. Maybe ask the question, actually. I'm so sorry.
Yeah. So given that you had no job offers lined up as of spring break of that year, you confided in Charles.
Yes, I did.
Okay. Who expressed to you that he was sure that Blake could pull some strings for you if you applied for an internship at Lush?
Yes. He said that, and I couldn't refuse, and so I decided to try. You know what I mean?
So you did apply
Yes.
and you did get the internship,
I did.
despite having no relevant prior job experience?
Yes. Yeah.
Okay, let's focus in on your employment at Lush now. You began your internship there in June 2003.
Yes, I did.
And your position, in that position, you were tasked with a research assignment.
Can you repeat that?
Sure. In that position, you were tasked with a research assignment,
Yes, I was.
which surrounded Drufo,
Yes.
and specifically one compound within the chemical bonding agent, not the entire agent.
No, I was just tasked with finding the chemical that comprised it.
Okay, and Drufo has many different components which make it up.
Yes.
Okay, and this research assignment was part of a larger study conducted by Lush?
Yes.
Okay, on Drufo.
Yes.
Okay, and during that research assignment, you ultimately only came across one relevant study, yes?
Yes.
Okay, let's talk about that study. It was conducted by a lab in England, yes?
Yes.
And this study showed no proof of Drufo being carcinogenic.
What? What was that last part?
This study showed no proof of Drufo being carcinogenic, correct?
It had shown that it had been carcinogenic in the rats and that there was possibility of it being carcinogenic in humans.
But it was only a possibility, no proof, correct?
There was no exact proof, but that's also what raised a bit of concern.
Okay, but just to clarify for the jury, it was only a possibility.
Yes.
Okay, and the test subjects, as you stated before, in the study were rats,
Yes.
not humans?
No.
Okay, but regardless, you wrote down the results of the study in your notebook, yes?
Yes, because I decided to be very because rats have very similar body organs to humans, which is very well known, and so that's what also piqued it to be written down and shared.
Okay, you're saying that rats have similar organs to humans?
Bodily organs, yes.
Okay, just to clarify, you're saying that rats have similar bodily organs to humans? Okay, I'll now ask my co-counsel to screen share Carson Durst's affidavit. You're aware that you wrote an affidavit in this case, yes?
Yes.
Okay, and I'll ask my co-counsel to scroll down to the bottom of this affidavit here. This is your signature, yes?
Yes.
Okay, and you were aware that you could change this statement at any time, yes?
Yes.
Okay, I'll now have co-counsel go back up to the top of this statement and just scroll through slowly for us. Okay, Ms. Durst, are you seeing anything within your affidavit about the bodily organs of rats being similar to that of humans?
No.
Okay, and that's because you never mentioned this in your witness statement, correct?
No.
Okay, thank you. Co-counsel can now stop screen sharing. Thank you. Okay, let's talk about Exhibit 4 now. And I'll ask co-counsel to screen share Exhibit 4.
All right.
And just let me know as soon as you're able to see it, Ms. Durst.
All right.
Okay, and I'll have my co-counsel scroll down just a little bit so we can see that second paragraph pretty clearly. I'll now ask you to read along silently as I read this paragraph aloud. Following our lab's June DRUFO study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year. So
Objection cumulative.
Ms. Miller?
Your Honor, this is not cumulative and does not apply to any objection under Rule 403 because if it were to, it would need to either mislead the jury, confuse the issues, or waste time, which it is doing none of. I know that the jury has a copy of this exhibit as it has previously been entered, but I'm trying to direct their and Mr.'s attention to one specific part of this exhibit to aid in my line of questioning.
Mr. Cooper, why is this cumulative?
Your Honor, this is already been entered into evidence as opposing counsel has stated. Therefore, the jury can read it on their own and does not need it to be read aloud. Yes.
Okay. Well, on cross-examination or even any examination, counsel is acting properly to direct the attention of the jury and the witness to certain provisions of an exhibit. And that direction and that discussion of those provisions are not part of any previous testimony, so it's not cumulative. The objection is overruled. Go ahead, Ms. Miller.
Thank you. And Mr. Just so you can follow along, I'm going to go ahead and pick up at that second sentence within that paragraph. So we are reinitiating the study in the coming weeks with fresh product samples. Development engineers and lab techs are also invited to participate in briefings by senior management on target market positions and economic strategies planned for DRUFO as the study refresh proceeds. Did I read that correctly, Ms. Durst?
I'm not sure. You broke out a lot when reading that.
Okay, just for the sake of time, I'll go ahead and move on. But from what you did hear, did it sound like all of that was exactly what's in that email?
I'm sorry,
The court
can you
will
repeat
direct-
that again?
The court will direct that it was correctly read. Go ahead, Ms. Moore.
Okay, thank you, Your Honor. And now my co-counsel can stop screen sharing. Thank you. Okay, so Mr. You claim to have brought up concerns around the potential carcinogenic qualities in DRUFO, yes?
Yes.
And you say that you've raised these within Lush.
What?
You say that these concerns that you raised internally within Lush.
What do you mean by that?
What I'm asking is when you raise these concerns, you raise them to other members of teams at Lush?
Yes, I did.
Okay, and you didn't feel like you were heard?
Well, what do you mean?
You didn't feel like those at your company were listening to you?
Yes.
Okay, and you didn't feel like they held the same care in reducing carcinogenic risks in DRUFO that you did?
Well, I can't be completely sure what they were thinking.
I'm not asking you what they're thinking, just what you felt. You felt that they did not hold these concerns in the same regard as you, no?
Well, I didn't know that how I felt and thought about it though. So
Mr. I'm just asking you to testify to how you felt. You felt that your concerns were not shared by your coworkers, correct?
yes.
Okay, but that was despite all of this research that we've just spent the last 5-7 minutes discussing.
What do you mean?
We just spent a substantial amount of time discussing internal studies at Lush. So your concerns were despite all of this research?
I think I'm still confused by your question.
Mistress, there's only so many ways I can clarify this. So if you could just answer it to the
I'm
best
so
of your
sorry.
ability. You claim that these were never addressed and weren't held in the same regard as your coworkers, though we just spent a substantial amount of time discussing all of the internal research that was done at Lush regarding carcinogenic qualities in Drufo.
Yes.
Okay, thank you, Your Honor, and thank you, Mr. No further questions at this time.
All right, thank you. Mr. Cooper, do you have any redirect within the scope of the cross-examination?
Yes,
I'm sorry, I couldn't hear what you said.
Yes, Your Honor.
Go ahead.
Did Lush conduct a study into humans?
Yes, they did.
What were the results?
Come back inconclusive.
But was there any concern?
Yes, that I could have non-Hodgkin's lymphoma.
And you did try to bring that to the bosses of Lush.
Yes, I did.
Objection, Your Honor, leading. The question just asked by opposing counsel implies the answer in the question and does not give Ms. Durst room to reply, and thus it's a leading question.
I don't think it was that leading, so overruled. Go ahead, Mr. Cooper.
And what did your bosses say to this finding?
To keep it in the walls, that there would be further analysis needed.
No further questions, Your Honor.
All right, thank you. Then the witness is excused. Okay, Holly, thank you.
Ready, Your Honor.
Ready, Your Honor.
All right, thank you very much. The plaintiff may call its next witness. Ms. Pavetti, is that you?
Yes, Your Honor.
All right.
Your Honor, the plaintiff's call Dr. Casey Rogers to the screen. And
All
Your
right, I'll remind the doctor that she remains under the oath she took at the beginning of this session. Go ahead. I'm sorry, Ms. Pavetti.
And Your Honor, before I begin, I would like to ask the timekeepers if they happen to have stopped time at any point during Mr. Cooper's direct examination, because I believe there were a lot of technical issues. And when I asked my timekeeper, he started with 16 minutes. And with the amount of technical issues he had, it took about a 12-minute direct that typically should not have been so.
All right, timekeepers, did you stop during the technical difficulties?
I didn't stop exactly when they were beginning because it was hard to tell if it was just me or if it was everybody in general. So there might have been like a minute. But besides that, I tried to stop the clock.
Okay, and you represent which team?
Michael, Your Honor.
Okay, got it. All right, thank you. How about?
I also tried to stop for multiple issues as best as I could.
All right, so how much time does Michael show and how much time does Toby show?
I have 4 minutes and 28 seconds, Your Honor.
I have 3 minutes and 58 seconds.
All right, we will go with 4 minutes, 28 seconds. So go ahead.
Thank you, Your Honor.
Your Honor, if I may, could I request for any more time due to the fact that there may have some time like discrepancies between not knowing whether or not it was just them or if it was everyone?
Well, I will give you 4:45 and let's squeeze it in by then, okay?
Yes, Your Honor.
Your Honor, before they start, can you allow the timekeepers to just start their clocks to that time and then
Yes, tell me when you are coordinated at 4:45.
I'm ready, Your Honor.
I'm ready, Your Honor.
All right, let's go.
Please state your name, spelling the last for the record.
Dr. Casey Rogers, Rogers.
Why are you here today?
I'm here to offer my expert testimony on behalf of the plaintiff for this matter.
Let's talk about a little bit about your educational background. What did you get your bachelor's degree in?
I got a bachelor's degree in chemistry and agriculture from Colorado State University.
Did you continue your education?
I did. I later got my PhD in agriculture in entomology from the University of California at Berkeley.
Are you a toxicologist?
I am a toxicologist. I have a research interest in toxicology and insect chemistry or pesticide chemistry.
Has your research been used before?
Of course, it's been used in front of many advice boards and litigations. I've also given my expert recommendations to many companies about what their employees can and cannot do if they're exposed to dangerous chemicals.
Have you conducted a study on Drufo?
I have conducted a study on Drufo. I conducted a study to see if there's any potentially negative harm or harmful effects Drufo can have on humans.
Your Honor, pursuant to Colorado Rule of Evidence 702, the plaintiff asked the court to accept Dr. Rogers as an expert in the fields of chemical toxicology on humans and Drufo toxicity and carcinogenicity.
Okay, is there an objection to the admission of this witness or the acceptance of this witness as an expert in the fields of chemical toxicology and carcinogenic effects?
I have no objection on the grounds of chemical toxicology, but I do object on the grounds of Drufo carcinogeneity. The fact of the matter is that we haven't heard adequate foundation that this witness has any knowledge or education, skill, or experience in that area.
It's okay. They're just wasting their time for cross because they have
Timekeeper, you're muted. Timekeeper, you're unmuted.
All right.
My apologies. Your Honor.
That's all right. This gets confusing and technical issues are challenging, so we'll just roll with it. Mr. Sheffner, are you done with your objection?
Everyone heard it, then yes.
Okay. Ms. Pavetti?
Your Honor, my witness testified to having conducted a study on Drufo toxicity and carcinogenicity. I just, however, cannot get into those details until she has been entered as an expert in what I have asked to qualify her in as.
All right. I think the testimony that she gave was that she has conducted a study of Drufo, and therefore I think she's adequately laid a foundation for her to testify as to those matters which are too difficult for me to pronounce. However, she's going to be accepted as an expert in the fields of chemical toxicity and the carcinogenic effects of Drufo. You may go ahead, Ms. Pavetti.
Dr. Rogers, let's talk a little bit about your study. How did you arrange it?
Well, I had 3 groups. The first, the control group for people who never came in contact with Drufo. The second was a group of people who came in contact with Drufo only on occasion. And the last group of people who came in contact with Drufo on a regular basis.
What were the results of the study?
Well, the results of the study did show that there was a correlation between Drufo and negative harmful effects. There is 10% people in the study who were exposed to Drufo on a regular basis were 10 times more likely to develop adverse health effects than the control group, and the group who came to contact with Drufo on occasion was 5 times more likely than the control group.
Was non-Hodgkin's lymphoma found as a result in the study?
Yes, there's 2 head cancers that were found in the study. They are in Doctor and Iragan variety, the latter of which includes non-Hodgkin's lymphoma.
Dr. Rogers, is there anything that can be done to mitigate the risks of exposure to Drufo?
Of course, you must understand that the harms of Drufo is breathing in as an aerosol or rubbing against the skin, so one must wear long sleeves, long clothing, and a mask.
Did you review Dakota Weirs' medical and employment records?
I did.
What did you find when analyzing her records compared to your study?
Well, Dakota Weirs worked in heavy landscaping for a period of 4 years. During this time, she did indeed come contact with Drufo.
There's an objection?
Yes, under the grounds of improper lay opinion. Would you like me to explain my objection?
I think you better.
We've heard so far that this witness is an expert in drufo carcinogeneity as well as chemical toxicology, but they don't have no reason to testify on an opinion about Dakota Wire specific medical records. They aren't an expert in that area. They don't have a medical doctorate.
Ms. Pavetti?
Yes, Your Honor. I'm asking the witness who reviewed the medical records and employment records, mainly comparing the witness or Dakota Weirs to her study, which she is an expert in for that matter. So she's mainly discussing the facts of her study with what Dakota Weirs has exhibited throughout their diagnosis of non-Hodgkin's lymphoma.
If I may respond, Your Honor.
Yes, Mr. Shefflin.
I don't dispute that my opposing counsel has laid adequate foundation that this witness has knowledge of these things. But under Rule 701, any witness testifying under an opinion must have it both be rationally based on their own perception. That's not an issue, but it also must not be based on any scientific or technical knowledge under Rule 702. Something like this in-depth understanding of medicine is outside of this witness's expertise. I would request they only testify on toxicology, that being the chemicals, rather than medicinal expertise.
Your Honor, if I may.
What, just hold on. What was the last phrase of your objection, your argument?
That they should only be testifying on the topic of toxicology and not on medicinal expertise.
Medicinal what?
Expertise.
Expertise. All right, thank you. Now, Ms. Pavetti?
Your Honor, Rule 701 is opinion testimony by lay witnesses, which is for when it is by a witness who is not an expert. And also, I'm still not asking her for any medical testimony. I'm asking her about results of her study that correlate with with Dakota Weirs.
You cut out on the last part of your statement. I'm sorry.
I'm still not asking Dr. Rogers for any medical testimony. I'm asking her to compare Dakota Weirs' records and non-Hodgkin's lymphoma exposure or diagnosis to her study.
Okay. I don't think that the objection based on 701 is pertinent when you have a qualified 702 expert. So she is allowed to give her opinions within the scope of the expertise she's been qualified to testify to. And I agree with the plaintiff's argument that the question is not asking for a medical diagnosis. It's asking for whether she reviewed the plaintiff's work records and other information, and she may compare that information to the results of her study and whether there is any correlation between those two, which I expect is where she's going. Therefore, the objection is overruled. Ms. Pavetti, go ahead.
Dr. Rogers, what did you find when analyzing her records compared to your study?
Well, Dakota Weirs worked at Hanley Landscaping for a period of 4 years. During this time, she was exposed to drufo on a regular basis. That and the results of my study would say that her condition is similar to those who were in the group of my study who came in contact with drufo on a regular basis. Given that, I can say with a high degree of certainty that Dakota Weirs did indeed develop non-Hodgkin's lymphoma because of her exposure to drufo.
No further questions, Your Honor.
All right, thank you. Mr. Shefflin, you have cross-examination.
I do. Could I get a quick time check first, though?
Yes. Timekeepers. 3:52.
I have 3:05, Your Honor.
You have 3:05?
Yep.
Well, we have some problems here.
I have a question for the other timekeeper if they started the clock while the voir dire was going on. For cross, or if they counted that for plaintiff's side, because that can be why. It's different times.
I counted that for the crossing attorney's time for the voir dire.
Okay, well,
Okay.
Would the timekeepers please set their clocks at 3:30?
Yes, Your Honor.
Yes, Your Honor.
Tell me when you're ready.
I'm ready now. Now, Dr. Rogers.
I'm ready, Your Honor.
No, wait. I'm asking the timekeepers to tell
Oh,
me when they're
my
ready.
apologies, Your Honor.
I'm ready, Your Honor.
Is that both of you?
Yes, Your Honor.
All right, let's go.
Now, you've testified earlier to a study that you've done on Drufo. Is that correct?
Are you referring to the study I was talking about? Because I've conducted more than one study and, well, I've written more than one thing about Drufo, but the study I did earlier was about Drufo. Yeah.
And you testified about the results of that study. Let me just clarify. Your third group with daily exposure were 10 times more likely than your control to contract non-Hodgkin's lymphoma. Is that correct?
Okay, so bit of clarification here. They were 10 times more likely to develop adverse health effects, not just non-Hodgkin's lymphoma. There were a wide variety of other things that came up during my study that were not just non-Hodgkin's lymphoma. There were two other kinds of cancers, endocrine and endocrine. Both are very important, both are different. They're also similar in some regards. However, they were not both non-Hodgkin's lymphoma. So in that case,
So just to clarify,
Excuse me?
they're 10 times more likely to contract adverse health effects then, correct?
people in the study who came in contact with Drufo on a regular basis are indeed 10 times more likely to develop adverse health effects according to my study.
Thank you. And your occasional use group, they were 5 times as likely as your control group?
They were 5 times more likely to develop adverse health effects in the control group. That is correct, yes.
Just to clarify one more time, that group with occasional exposure, that's 5 times more likely.
Yes, 5 times.
Now, Dr. Rogers, did you write an affidavit for this case?
An affidavit. I have my CV and I have my list of publications, which are both in the exhibit list.
Did you write an affidavit for this case, though?
In regards to COVID wears?
This is with regard to your witness statement.
Yes.
I do not believe so.
You didn't write an affidavit in this case.
Oh, are you talking about my witness statement? I did write
Yes, your witness statement.
it. Sorry, I got confused. I thought you were saying something else.
It's no worries. Would you recognize this witness statement if it was shown to you?
Of course.
In that case, I'll ask my co-counsel to show that witness statement. Could you scroll down to the bottom of that statement there? And now that's your signature. Is that correct, Dr. Rogers?
Hold on, this hadn't finished scrolling for me. Yes, it is indeed.
In that case, could we scroll back up to, I believe that is line 47. Please read along silently as I read aloud. Those with prolonged exposure.
Well, hold on, it hasn't got there yet.
That's okay.
There we go.
Those with prolonged exposure were 10 times more likely to be diagnosed with cancer as those without exposure, and 5 times more likely to be diagnosed with cancer as those with occasional exposure. So that means that your group with daily exposure was actually 5 times more likely than your group with occasional exposure. Not that your group with occasional exposure was 5 times more likely than your control group.
No. I think you misunderstand. So the group that was exposed to Drufo on a daily basis were 10 times more likely to diagnose cancer, or
5 times more likely to be diagnosed than those with occasional exposure. Is that correct?
Let's hold on.
Objection, Your Honor, misquoting the witness.
All right, I don't think that he's misquoting. I think they're arguing about what the statement says.
Yes, Your Honor.
In that case, is that correct? The group with prolonged exposure is 5 times more likely
That's
than those with
time.
occasional exposure.
That's time.
In that case,
All
Your
right.
Honor, I have no further questions.
Well, I'm going to allow,
It's-
I'm going to allow the witness to answer that last question without penalty. So witness, would you please answer the question?
Can you repeat the question?
Yes. Just there in your affidavit, it says those with prolonged exposure were 10 times more likely to be diagnosed with cancer as those without exposure, and 5 times more likely to be diagnosed with cancer than those with occasional exposure.
Yes.
Thank you.
All right, thank you. Ms. Pavetti, do you have any redirect?
Yes, Your Honor.
And do you have any time? I guess that's a
I
question.
believe I do.
You have 1 minute and 6 seconds.
All right, thank you.
My co-counsel could stop sharing that exhibit, by the way.
Dr. Rogers, those results, are they accurate?
Of course,
How do you know?
because I conducted a study based on that. And I have reviewed it and yeah,
Is it true and accurate to the best of your knowledge?
it is.
No further questions, Your Honor.
All right, thank you. Then the witness is excused, and thank you for hurrying through your testimony. I know you're under a time crunch.
Yes, Your Honor. At this time, the plaintiffs rest.
All right, thank you. Holly, thank you. Linda,
I'm
thank
ready,
you.
Ron.
All right, Stephen, thank you. Defendants, you may call your first witness.
We do, Your Honor. The defense calls Dr. Devin Williams to the stand.
I'll remind the witness that the oath taken at the beginning of this session remains in effect. Go ahead, Mr. Shefflin.
Now, Dr. Williams, could you please state your name and spell your last for the benefit of the court?
Yeah, of course. That's Dr. Devin Williams, Williams.
And Dr. Williams, what do you do?
I lead Lush's toxicology research and development labs, and I'm also a professor.
Well, more specifically, what do you do at that job?
I work within the agricultural research and development of Lush's products.
Did you go to school at all to get that position?
Yes, I did actually. My undergrad to my PhD was completed at Colorado State University in pharmacology and toxicology. And I did a specialized post-PhD program, at the University of Utah in pharmacotoxicology.
And after completing your education, did you have any other work experience before Lush?
Yeah, I did. I worked at the Lamar County's chief toxicologist's office, hands-on in the field.
And just for the benefit of the jury before I move on, what is toxicology?
Oh yeah, no problem. Toxicology is a field of research in which scientists analyze the harms of a certain chemical or the use of a chemical and how to neutralize those harms.
Do you think everything you've testified to today would help you aid the jury in understanding this case?
Yeah, definitely. I've worked at Lush since about 2010, as well as my other professor jobs, and I do think it's a vast amount of knowledge, as well as many years of schooling.
In that case, Your Honor, I would like to tender this witness as an expert in the fields of toxicology and agricultural development under Rule 702.
Ms. Pavetti, do you have any objection to the acceptance of Dr. Williams as an expert in the fields of toxicology and agricultural development?
Yes, Your Honor, a brief voir dire.
Go ahead.
Dr. Williams, when you joined Lush, half the original Drufo team had already moved on, correct?
Yes, they did.
And you started as a technician, not a toxicologist?
I did start as a technician. Yes, that is correct.
And you never really worked with Drufo personally?
I've worked within Lush's toxicology of Drufo for coming on 12 years now. So.
And Dr. Williams, you mainly oversee environmental impacts, correct?
Yes, that is correct.
Not human impacts, correct?
Not mainly, but it is still a part of research I do at Lush.
And just to be clear, you work for the defendant company, Lush Fertilizer?
Yes,
Your Honor.
I work for Lush Fertilizer.
Could I inquire as to the relevance of the defendant's employment?
Well, I think the relevance is fairly obvious, and that is the potential bias of the witness in favor of her employer. Ms. Pavetti, do you have an objection to the acceptance of this witness as an expert?
Well, I was not entirely done with my voir dire, but no.
I'm sorry. Well, go ahead.
Okay, thank you, Your Honor. Just to be clear, you work for the defendant company, Lush Fertilizer?
Yes, Lush is a very big brand. Many people do. I work to keep its products environmentally friendly, and really it's just a nice environment to be at.
So you are not an independent expert?
What do you mean by that?
Meaning that you are not hired from outside of the company, you were hired from inside of the company, from which you are paid.
Yes, I am paid working for Lush, and I do work for Lush's corporation. It would make a lot of sense to be testifying on their behalf as a paid employee, as I do know the nitty-gritty within the research and development of their products.
Thank you, Dr. Williams. Your Honor, we have one objection to this witness being entered in the field of toxicology. We ask that she make no expert testimony in the fields of human toxicology due to the fact that she oversees the environmental impacts, not the humans that may be affected.
Your Honor, may I respond?
Yes, you may.
An expert witness needs only one of knowledge, education, skill, and experience to be able to testify on a matter. We've already learned that this witness was part of the chief toxicologist office in Larimer County. They're well aware of human toxicology, even if they don't do that in their job.
All right. Well, she also testified that human toxicology was part of the general responsibilities of her job at the defendant, and therefore I think she is qualified to provide helpful information to the jury in the fields of toxicology, including human toxicology and agricultural development. So go ahead, Mr. Shefflin, and ask your questions.
I'll begin now then, Your Honor. Now, you said you work at Lush. Could you talk more about that?
Yes, of course. So I work within researching the toxicology of Lush's products.
And is there any one specific product you research?
Yes, I work on Drufo.
What is Drufo?
Drufo is Lush's patented bonding agent, which means it binds ingredients in fertilizer to the product it's being sprayed onto.
And why does Lush make their product that way?
Mainly makes it to keep its company environmentally sustainable and to stop the eutrophication process.
I'm sorry, I haven't heard of eutrophication before personally. Could you explain what that is?
Yeah, no problem. So eutrophication, to put it simply, is the process of which nitrates coming from nitrogen in soil and bacteria get pushed into the environment, which can cause algae blooms, which can really hurt fish and just overall not a good process.
Well, now that we know a bit more about Lush, let's move on towards the ultimate matter of this case. Now, have you reviewed any toxicology information surrounding Drufo?
Yes, like I said before, I've worked at Lush since 2010, leading labs for about 7 years now, and I've really done extensive research and some vast knowledge on the subject.
And what has this information shown you?
All of my information that I've gathered has shown me that there's no direct correlation between the uses of Lush's products and cancer, and more importantly, there's no direct correlation between the use of Drufo and non-Hodgkin lymphoma.
Well, now we understand the data that you've seen, but I'm sure everyone's heard some other differing opinions today. Have you heard anything about Casey Rogers' study?
Yeah, I have actually.
And have you reviewed that study at all?
I have, yes.
Have you heard other scientists say anything about it?
That's actually a really important question. Other scientists haven't seen the study as it is not peer-reviewed or published.
Well, in that case, what are your individual opinions on this study?
I'm so sorry. Can you repeat your question?
I'm happy to. What are your individual opinions on Casey Rogers' study?
In my opinion, I do believe it was conducted improperly, and I don't think the results should be used in a formal setting like this.
And why is that?
Casey Rogers' study looked at many different groups of control areas, and the people in the study were not taken into account for any other environmental effects that could have swayed the verdict of the study.
So sure, about environmental effects. How would you have done a study to account for these?
I would have strictly looked at it across different groups of farmers interacting or not interacting with Drufo. That way there were no other lacks within it.
I apologize. I'm also not super familiar with the scientific method itself. Could you put that in terms that might be easier to understand?
Yeah, of course, no problem. So I would look at it on a basis of apples to apples, comparing different groups of farmers as the apples. Whereas Casey Rogers' study more looked at it of apples to oranges, comparing different groups of people who have different lifestyles, coming into account with pesticides or plant food, and it really just made inclusive results.
Well, that makes sense to me. I have no further questions for you.
All right, thank you. Ms. Pavetti, you have cross-examination?
Yes, Your Honor. Dr. Williams, you believe Drufo to be revolutionary?
Yes, I do. It's a really amazing product. What Lush is doing, I'm just really proud of how far we've come.
That's wonderful. But Drufo is supposed to eliminate the amount of nitrates released into nature, correct?
Drufo helps with eutrophication process, if that's what you're asking.
Well, yes, eutrophication can be caused by the excess amount of nitrates that may be released from Drufo, correct?
Not released from Drufo particularly, but released from nitrogen in the soil and bacteria being turned into nitrates, yes.
However, Drufo doesn't eliminate nitrates, it eliminates the amount of fertilizer being used, correct?
Yes, that's one of the ways we keep it environmentally sustainable. The less fertilizer is used, the less gets washed away into the environment. And it's really one of our main factors into why we make Drufo that way and why Lush keeps its products industry leading.
Thank you. And the European Union has denied Drufo being used in there because of its nitrate directive.
Because of nitrate accumulation, yes.
You state that you have reviewed the data and that the data shows that non-Hodgkin's lymphoma is not caused by Drufo?
Yes, I do believe that's true, in my expert opinion.
However, that data is not here in court today, correct?
No, it's been accounted for by many vast studies done at Lush's toxicology wing of their research, and it would really take a lot of paper and frankly a lot of work to bring all the studies in. As we have been working on this for in my work at Lush over 12 years, and that is just our verdict that we've come from many vast studies.
So Dr. Williams, it was too much work to bring in the data for this case?
No, that's not
Your Honor. Lack of personal knowledge. Would you like me to explain my objection?
Not really. She testified that it would be too much work to bring it in, so I think it's a fair question.
Would you like me to repeat it?
Sure.
So you're saying that it would have been too much work to bring in the data to this case?
I mean, not precisely. It would just take a lot of extra help, and frankly, I feel like that would be a waste of our time.
Thank you. You made testimony on Dr. Rogers' study during direct, correct?
Yes, I did do that.
You criticized Dr. Rogers for numerous things, correct?
Yes, that is true.
Such as for it not being peer reviewed or replicated, or maybe some other things, correct?
Yes, that is true.
But most of those criticisms go along with the scientific method, correct?
Yes, Dr. Rogers' study really doesn't follow scientific method anyway.
So you're really just criticizing the way her study was handled, not really the way the study ended up, correct?
No, I am really looking at both sides of it. The study, its handle itself wasn't done properly, and I do believe the results of the study shouldn't be used.
You also believe that Dr. Rogers has a financial interest in her study?
Yes, I do. Dr. Rogers' study had a hypothesis in which was directly found with the conclusion of the study, and it really brings in the big question of, did Dr. Rogers really just find what they were looking for and ended at that? Because that has been their search through their whole science studies across many years.
Of course. So you have worked at Lush Fertilizer for 10 years now, or over 10 years?
Yeah, coming up on 12.
Your career has grown significantly, correct?
It has. I've done many years of education to get to this job, and I'm really happy with where I am.
You came all the way from technician to the head of a whole department, correct?
Yes, I did.
So it's fair to say that Lush has been very good to you.
Yes, it's taken a lot of work to get where I am, but I do believe it is well deserved.
Including financially, correct?
You could say that.
Yes, I could, but would you say that?
That's a good question.
No further questions, Your Honor.
All right, Mr. Shefflin, do you have any redirect within the scope of the cross?
I do.
Go ahead.
Now, you talked a little bit in cross about nitrate elimination from Drufo. I think you handled that pretty clearly, but I'm still a bit confused about the EU ban. Could you speak on that more?
Yes, so the EU simply put a ban on our product Drufo. It was really because of nitrate accumulation. They had some laboratory conditions, were inconclusive with what we would see in nature. And because of that, the nitrate accumulation was not taken into account for directly and fully, and it didn't give them a full look on our products and the effect they have.
And just to be clear, does that have anything to do with the risk of contracting cancer?
In no way, the EU was not even worried about that.
Well, then on the topic of the nitrate ban, is your team doing anything about that?
Yes, we are. We are currently in the process, of conducting a study that we are hoping to submit into the EU to hopefully change their opinion on the nitrate accumulation.
All right, let's move on from that line of questioning a little bit and talk about the studies you have reviewed in your data. Now, when were you brought on to Lush?
I was brought on in 2010.
And what were you working in there when you were first brought on?
Initially, I was a fill-in technician, but that job was really way below what my knowledge and what my vast years of schooling have given me.
So how long have you been studying the toxicology of Drufo with Lush?
12 years. It's really been vast amounts of studies.
Well, in that case, let's move on a little bit from there as well and talk about Casey Rogers' study. Now, could you explain why you take issue with Casey Rogers' results?
I think the primary, actually, not even I think, in my expert opinion, the primary reason I have an issue with Casey Rogers' study is that it didn't take into account for of the different lifestyles between the control groups of their study.
So you don't object, or I'll rephrase that question. So are you objecting to just the method of the study or just the results? I just want to clear that up a little bit.
No, I'm really objecting to the whole study.
In that case, Your Honor, I have no further questions.
All right, thank you. The witness is dismissed.
I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. The defense may call its next witness.
Thank you, Your Honor. Defense calls Skylar Wise to the stand.
Good evening. If I could just have a second to change my name. I'm sorry about that. Okay.
That's right. Go ahead.
Good afternoon. Can you please state your name and spell your last for the record?
Absolutely. My name is Skylar Wires, W-E-I-R-S.
That's interesting. We've heard someone with the same last name testify earlier today, didn't we?
Yeah, actually we have. They're my twin, Dakota. You know, shared a womb for 9 months, kind of makes us twins.
That's interesting. You're testifying on the opposite side of your twin?
I am, yeah.
Could you elaborate farther on that?
Absolutely. Well, my twin, Dakota, believes that Lush fertilizer caused their illness in this case. And I mean, I've seen proof that that simply isn't true.
Thank you. We'll come back in a little bit to more about your relationship with Dakota, but let's talk a little bit more about we'll talk about your credentials. What do you currently do for a living?
Well, I currently do quite a lot, if I will be honest. However, I am a freelance investigative journalist for The Rationalist. So,
What's The Rationalist?
well, The Rationalist, it's a pretty cool organization. It's a nonprofit devoted to basically stopping the spread of pseudoscience. More specifically, I work for the journalism team they have that releases a quarterly article or a quarterly magazine devoted to the same goal.
You mentioned pseudoscience. What is pseudoscience?
Well, pseudoscience, put it simply, is just science with no basis in reality.
And what kind of magazine is The Rationalist?
Well, it is first and foremost a scientific advocacy and educational magazine.
And have you written any articles or series that may pertain to this case?
I have actually, yeah. Well, I wrote a series on the agri-tech industry as a whole. However, I also wrote an article that was focusing on Drufo and lush fertilizer.
How long did you take to research this series?
Just under a year, actually.
And when did you publish this series, or when was this series published?
Coincidentally, actually, before Dakota was diagnosed with non-Hodgkin's lymphoma.
And in this research that took about a year, what sources did you use?
Well, I can honestly talk about every single individual company I used. However, obviously, we don't have that time. We don't want to be here all day. Primarily, I used the USDA and NASDA, which are two very well-maintained government resources.
And what are the USDA and NASDA?
Well, they're pretty long acronyms and they have even longer names. The USDA is the United States Department of Agriculture, and the NASDA is the National Association of State Departments of Agriculture.
How would you describe your level of knowledge within the agri-tech industry?
Well, that is a doozy of a question, if I'm being honest. Really, I believe I have the best well-rounded knowledge other than pretty much anyone in the agri-tech industry.
Your Honor, under Rule 702, I would like to qualify Mr. Wires as an expert in the agri-tech industry based on their level of knowledge and based on prior rulings made by the court.
All right, Mr. Cooper, do you have any objection to the acceptance of this witness as an expert in the field of the agri-tech industry?
Yes, Your Honor. A brief voir dire.
Go ahead.
You have no college degree, correct?
No, I don't actually.
Meaning you have no training or education besides a high school diploma, correct?
Well, a high school diploma as well as, a couple years in the industry, but yeah.
So you have no formal training about agricultural technology, correct?
None about agri-tech, no.
And you have no CV or resume that you have provided to this court today?
I feel the need to provide one.
And you haven't worked with Drufo or any possibly carcinogenic chemicals in a lab, correct?
Not in a lab, no.
And your research into Drufo lasted less than a year, correct?
Yeah, just under a year.
And as you didn't work in a lab, all of your research was on paper or the internet or interviews?
Yeah, pretty much.
And could there have been a bias, or I'm sorry, could you have had a bias in the sources that you chose to read and use in your research?
Well, what do you mean by that exactly? What type of
bias? Could there have been a bias in the sources that you try to read? For example, people when reading news usually will only read one side.
Well, I chose a very large array of resources to pick from, so any biases that those publications might have had pretty much been nullified.
I was asking about the bias of whatever you read. I was asking about a bias that you may have had. Was it possible?
My apologies. Well, I don't know why I would have a bias. this was before I knew of Dakota's condition, or really anyone knew of Dakota's condition. So I have no reason to sway the way I wrote.
And you work for Rationalist magazine?
I do, yeah. Really cool company.
And they pay you salary, correct?
Yeah, or they pay me on an article by article basis.
But they pay you, correct?
They do pay me, yeah.
Okay. And your editor picked you to write an article about Drufo, correct?
About the agritech industry as a whole. They kind of gave me free reign on what in the agritech industry I could write about.
And Drufo was part of that series?
Yeah, it was a really interesting part of that too.
And Rationalist is a magazine devoted to resisting the spread of pseudoscience.
You bet it is. That's one of their key ideals.
And your articles are written in aid of this idea?
Yeah, I mean, if we were spreading pseudoscience, what kind of organization would we be, really?
So you believe that the link between cancer and Drufo is pseudoscience, correct?
Well, I believe from everything I've seen, there have been no definitive proof that Drufo and lush fertilizer as a whole causes cancer. So yes, I would say.
I think at this point, I'm going to insert myself and say that this is voir dire regarding the qualifications of this witness to testify as an expert in the field of agritech industry. And the substance of his opinions are something that can be explored during his testimony and cross-examination. So if you have established an objection, Mr. Cooper, you should make it. And I can rule on whether he's going to go forward as an expert witness.
Yes, Your Honor. Before I do that, may I ask one more question?
That depends on what it is.
I would like to ask the witness that their editor did assign them to write specifically in favor of Drufo.
I don't see how that affects his qualifications to testify as an expert. You may want to use that as something to establish his credibility, but if you have an objection, please state it.
I do have an objection, Your Honor. At this time, we object to Skylar Weirs being entered as an expert. Under Rule 702, Skylar Weirs has not shown adequate knowledge, skill, experience, training, or education, and the defense has not met the burden put forth in the pretrial ruling on this issue to establish that Skylar Weirs has specialized knowledge beyond that held by the average juror. An expert witness is supposed to help educate the jury, and we believe that the existing bias that I have proven that this witness may hold may end up confusing the jury.
May I respond?
All right, Ms. Bono, would you please respond?
I have laid ample foundation. I have showed that Mr. Weirs has written not only just an article, but a series on the agritech industry as a whole, and he used qualified sources such as government agencies and actual agritech industries sources. And not only that, he has testified to the fact that he has extensive level of knowledge besides the average person, and he doesn't need education, training, or experience to be qualified. He just needs knowledge, which, as I've stated, I've laid ample foundation to the fact that he has enough knowledge. And yeah.
All right, thank you.
Your Honor, if I may.
No, you may not. The defense has established that, and in conjunction with the pretrial order, has established that this witness has created a knowledge bank in himself through investigations into documents published by the USDA and the NSDA, including certain publications that regrettably he has not disclosed. And I think that that is sufficient to establish himself as a person with knowledge that is going to be more than the average layperson, and that he has knowledge that would be able to assist the jury in understanding the facts of this case. As for bias, I don't think bias is an issue that goes to the qualifications of an expert witness, because if it were, every expert witness would be disqualified, because all of them or at least 99% of them are hired to provide an opinion, and therefore they have an inherent bias going forward. So we could never have an expert witness, which may or may not be a good thing, but it's not reason to disqualify the person as an expert. And so the objection is overruled. Mr. Weir is accepted as an expert in the field of agri-tech industry. Ms. Bono, you may go forward with your examination.
Thank you. Mr. Wires, I forgot to ask, what is agri-tech?
Oh, well, agri-tech is really a pretty broad term. But to put it simply, it is technology used to increase agricultural yield, be this fertilizers or even tractors.
And you mentioned that you wrote an article on Drufo?
I did, really cool article.
And what is Drufo?
Well, Drufo, it's honestly a phenomenal product, and I'm amazed Lush was able to make it. It is a bonding agent as well as a pesticide, and an incredibly good one at that.
Now, you mentioned two things there, and we'll focus in on each of them separately. What do you mean by it's a bonding agent?
Well, by bonding agent, I mean it is applied to a fertilizer to basically keep everything in everything in Lush fertilizer, be that calcium, nitrogen, phosphorus, everything in there on the plant instead of, say, in your water supply.
And what is the benefit of this?
Well, because it is able to keep everything on the plant, not only does it need to be applied less, however, it also means it is much safer for the environment as a whole.
You mentioned that it doubles as a pesticide. What does that mean for Drufo?
Yeah, well, honestly, it's incredible that they got it to do this. However, it doubles as a pesticide, meaning they're able to keep several known and dangerous carcinogens like arsenic out of the product.
And what is the benefit of this?
Well, other than, keeping out things like arsenic and glyphosates out of the product, it is also able to just decrease the amount of carcinogens or pesticides you would use otherwise.
And so because of these benefits of Drufo, how does it, in your expert opinion, compare to other products on the market or ingredients?
Boy, well, Drufo is honestly leagues safer than basically everything on the market. I mean, that's the truth after all.
And we keep mentioning this company, Lush Fertilizer. What is Lush Fertilizer?
Well, Lush Fertilizer, honestly, an amazing company, just like the Rationalist. Well, they're just like the Rationalist in that they're an amazing company, not in that they do the same work. Lush Fertilizer is a fertilizer company. Yeah.
And how does Lush as a company compare to other companies in the agri-tech industry?
Yeah, well, Lush Fertilizer is basically on the top of the game right now. No other agri-tech company has Drufo or has the ability to recreate Drufo. So they basically are above the competition in every way.
So since it's at the top of the game, does that mean that other companies like it?
Well, actually, a lot of companies frown upon Lush Fertilizer, if you will, especially a section of the agri-tech industry called the Old Guard.
What's the Old Guard?
Well, that's a good question. The Old Guard is a established section of the agri-tech community, basically the originals, if you will. And they don't like that Drufo is changing the game for everyone. So they have spent literally billions of dollars to slander Lush Fertilizer's name. And I mean, this isn't even the first time it happened. When Monsanto was just on the verge of cracking the corn gene, if you will, they spent an untold amount of money to slander their name. And I mean, I'm sad because it worked. And I just don't want that to happen to Lush here today.
Now, moving on a little bit, just talking about your relationship with Dakota, did you two ever discuss their work at Haven?
We did, yeah.
And did they ever tell you about any of the products they used while at Haven?
Yeah, absolutely, they did. They told me about quite a few.
And what were these products?
Well, one of the main products we talked about was a grass seed product they laid that was treated with synthetic nitrogen, just like pretty much everything else in the agritech industry. However, it was also treated with 2,4-D, a pesticide that, because it didn't have Drufo in it, wasn't able to keep out these dangerous carcinogens that Drufo was able to keep out.
So how does these grass seed products compare to Drufo?
Well, they're kind of uncomparable. One is a seed and the other is a fertilizer or a part of a fertilizer. However, a much better comparison would be 2,4-D and Drufo. And I mean, Drufo is leagues ahead of 2,4-D.
So within safety levels, how does Drufo compare to 2,4-D within the agritech industry?
It is much safer, just overall.
Did they ever discuss the inner workings of Haven with you?
Yeah, they did actually.
And how does the inner workings of Haven compare to other companies within the agritech industry that you've researched?
Well, given the fact that they had a 14.
Objection, Your Honor, this is outside the expertise of the witness.
I'm sorry, Mr. Cooper, I didn't understand what you said.
This is outside the expertise of the witness.
How so?
This witness is not Dakota Weirs and is testifying on behalf of what happened at of the inner workings of Haven Landscaping and things like that. And I understand that Skylar Weirs is testifying that Dakota told them that, but Dakota would be the better witness to testify on that. And as they have already testified, this is outside the scope of the expertise of the witness.
May I
Ms.
respond?
Bono?
Yes. This is completely within Mr. Wire's realm of expertise. He has done numerous research on the agritech industry and companies within the agritech industry. So he's well within his level of knowledge to discuss how Haven would compare to these other companies he's researched. And because he and Dakota discussed these inner workings, he has ample knowledge to be able to describe Haven within his knowledge that he has.
Okay, I think the foundation has been laid through his testimony that he has acquired knowledge about the inner workings of Havens, and those inner workings he's allowed to compare to his generalized knowledge of the agritech industry, and therefore the objection is overruled. Go ahead, Ms. Bono.
Mr. Wires, would you like me to re-ask my question?
No need. So, like I was saying, they had a 14-year-old working with chemicals. I mean, that's, they were 14. However, from what I've heard from Dakota, they also didn't supply proper PPE. And from what I've heard as well, Dakota didn't wear proper PPE.
In an earlier statement, you mentioned that Lush was the wrong people.
Okay.
So in your expert opinion, who is the right people?
Well, I'll be honest. I mean, I think it's clear here. Haven's at fault.
Thank you, Mr. Wires, and thank you, Your Honor. No further questions.
All right, thank you. Mr. Cooper, you have cross-examination.
Yes, sir. Let's talk about the chemical compound called Drufo. You wrote about Drufo, correct?
I did, yeah. Really good article. One of my best works.
And your research on Drufo was part of a series on modern agricultural technology?
You bet it was.
Not just on Drufo?
Nope, not just on Drufo.
And your sibling was exposed to Drufo, correct?
Yeah, they were. Basically every day from what I've heard.
But you weren't exposed to Drufo?
I wasn't, no.
Because you didn't do landscaping?
No, I've got a pretty bad grass allergy, and I mean, I would love to go out and play sports or work at a landscaping company, but I'm not able to.
And Dakota said that you did everything together. Isn't this true?
Well, there were obviously some differences, like the landscaping company she worked at, or I mean, also the piano playing. I wish I was such a good piano player like her. However, I simply didn't put in the time, and honestly, I'm not that interested in it.
Well, everything besides the exposed to Drufo and those things that you just listed.
Yeah, pretty much.
And you're testifying against them, correct?
Against who exactly? Dakota?
Yes.
Yeah, I am.
And you said that in your statement, Drufo is an effective pesticide, correct?
It is, yeah.
And pesticides are poison by definition, correct?
Yeah, absolutely. You should definitely not ingest any fertilizers or pesticides, and you definitely should get them in your eyes.
Now, let's talk about agricultural technology. You said that besides the US government, you have the best knowledge of anyone. Isn't that true?
Well, well-rounded knowledge, and specifically the USDA and NASDA. I guarantee agency like maybe the CIA would not have as well knowledge as the agri-tech industry as I do. Yeah.
And your research was only on paper, and you found out more knowledge than scientists that have been working far longer than a year. That's what you're claiming, correct?
Well, to be specific, yeah, if say a scientist, someone who say researched Drufo for 10, 20 years, I obviously wouldn't know as much as them specifically on Drufo, but something like say the inner workings of a tractor or what's the best way to maximize crop efficiency, they definitely would not know as much as me.
No further questions, Your Honor.
All right, thank you. Ms. Bono, do you have any redirect within the scope of the cross?
Yes, Your Honor. Mr. Wires, opposing counsel asked you about how you were testifying against your own twin, and we touched on it briefly, but would you like to go into a little bit more detail about it?
Yeah, sure. I would love to. Just let me patch up.
Could you go into a little bit more detail?
Yeah, sure. Well, I'm testifying against, Dakota, my twin. And I mean, I honestly don't want to. If they were going after, say, Haven, I would be right there by their side. However, they're going after the wrong company. They're going after Lush, the one company that actively wants to help them.
So are you testifying because you love your twin?
I'm testifying because I think my twin is misguided and I simply want to show them the truth behind the truth.
Thank you, Mr. Wires, and thank you, Your Honor. No further questions.
All right, then the witness is excused.
I'm ready, Your Honor.
Thank you. Thank
I'm
you,
good, Your
Howard.
Honor.
Thank you, Stephen. The defendant may call its next witness.
Your Honor, the defense calls our final witness, Blake Doncourt, to the stand. And I'll just ask that you give both Ms. Doncourt and I 1 moment to change our names on the screen so they accurately reflect who's going.
All right. I'll remind the witness that the oath she took at the beginning of this session remains in effect.
Okay, Ms. Doncourt, it appears as though you're on my screen. Are you able to hear me and everything?
Yes, I am.
Okay, great. And Your Honor, may I proceed?
Yes, you may.
Thank you. Okay, Ms. Doncourt, please state your name and spell your last for the record.
Well, my name is Blake Doncourt, Doncourt.
Okay, let's start off with some of your knowledge of the company Lush Fertilizer. And just for the sake of time, if you could keep your answers brief, that would be appreciated. Do you have knowledge of the company Lush Fertilizer?
As a matter of fact, I do.
How?
I am its founder and current CEO.
Okay, Ms. Doncourt, you seem a little agitated about being here today. Why is that?
I'm a little agitated because I do not believe that Lush should be here being sued right now.
Why?
Because it is not right when we have put so much care and time and effort into building the best product that we have.
Okay, yeah, you mentioned products. What types of products does Lush Fertilizer produce?
We produce fertilizer products.
Okay, and who all has been known to use those products?
Anywhere from small businesses to governments to individuals.
Okay, and will you tell me briefly about the work that it took to make Lush into the company that it is today?
I wish I could go on and on about this, but it took many, many sleepless nights and long days to build the company up to what it is now.
Okay, and are there any routine practices that are followed at your company?
Yes, we daily practice environmentalism.
Yeah, will you explain that a little bit more to me?
We put environmentalism at the forefront of every decision we make here at Lush, just because we care so much.
Okay, and we've heard quite a bit about Drufo, your company's flagship product today. So I'd like to have the opportunity to discuss it with you. Was Drufo developed internally within Lush?
Yes, it was.
How?
It was developed way back when I started the company, and then our researchers and scientists tested it extensively to make sure that it was not only the safest product to put out on the market, but the best.
Okay, you mentioned safety. Let's talk about that a little bit more. Has Lush always conducted its studies regarding Drufo internally?
Yes, it always has.
And as CEO, do you get to see these internal studies?
I'm a part of every conversation and email chain dealing with Drufo.
Okay, and when you put your product on the market, was it ever identified as a specific risk to persons who may come in contact with it?
No, it was never identified as such.
Okay, and have you ever been made aware that Drufo contains small risks?
Yes, I have been made aware of that fact.
Okay, but have you ever seen a study showing conclusively that Drufo is linked to non-Hodgkin's lymphoma?
No, I have never seen such a study.
Okay, thank you, Ms. Doncourt, and thank you, Your Honor. I have no further questions at this time.
All right, thank you. Ms. Hollaback, you have cross-examination.
Yes, Your Honor. Your company is the creator of the product known as Drufo, correct?
Yes, we are.
And you stated in your statement that since 2000, you have grown the company from an unknown producer of fertilizer to one of the world's largest supplies of yard and commercial fertilizer.
Yes, I grew up the company.
And you started developing Drufo back in 2000, yes?
Excuse me, but where does it say that in my affidavit?
I do believe you said you started creating the company in 2000, and roughly around that time, you started the production of Drufo.
I am not aware that I ever wrote that in my affidavit.
Sorry, let me clarify. Carson Durst testified today that he started doing testing on the product Drufo in the early 2000s, correct? And
Your Honor, this is outside the scope, of my witness's knowledge and outside the scope of her affidavit. According to the rules of competition, all witnesses are bound to their prior statements and nothing more. And so she cannot testify on what Carson Durst has previously said, even if she was here in trial today while Carson Durst went according to the rules of competition.
Ms. Hollaback?
Your Honor, if I may, because Mrs. Doncourt was here in court and did hear Carson's statement, I do believe she would know, as she stated, she's been a part of every single testing and conversation on Drufo, so she would in fact know when her flagship product started to be developed.
6.1.
Well, I am frankly very confused because there was testimony by a prior witness, and this is the CEO, and she has said that she's been involved in the development of this product from the beginning. So there seems to be some confusion. It doesn't really matter whether she actually put it in her witness statement, but it does seem that she would have some knowledge about what happened when she's the founder of the company. So maybe you can just clarify what the discrepancy is and what the confusion is, because it doesn't seem to be that important a point.
Of course. Would you like me to ask the question, Ms. Doncourt?
Yes.
And you started developing Drufo in 2000, yes?
Right when I started the company, I believe.
Okay. So just to clarify, you started developing your flagship product during the lowest financial point in your company?
Yes, to get our company off the ground.
And at this time, Lush Fertilizer was responsible for testing the safety of this product, correct?
Yes, very much so.
And also around this point in time, you were sent an email concerning the risk of DRUFA, were you not?
Could you please show me this email?
Of course. Could you please refer to Exhibit 4? I believe my co-counsel will be sharing it on their screen. Can you see this, Ms. Doncourt?
Yes, my eyes are a little fuzzy, but yes.
Of course. Is this the email sent to the leadership of Lush Fertilizer Incorporated?
It seems to be so.
And is this your name in the address section of the email? If you'd like, my co-counsel can zoom in their screen to show you that section.
Please zoom in.
Address section. Is it easier to read now, Ms. Doncourt?
Yes, it very much is.
So would you like me to re-ask the question?
No, I believe you said my name was on the to whom it's sent list.
Yes, it is. Do you identify that?
Yes, I do. My name is on there.
So, and to clarify, does this email contain information regarding the potential carcinogenic effects of DRUFA?
It seems to be some.
And you are listening on this email as receiving it, correct?
I have no personal recollection of this, and I believe this exhibit was provided to the courts by Carson Durst.
Right, and just to clarify, you had previously stated that you were a part of every email and conversation at your company, correct?
Yes.
So you would have known if you were sent an email like this?
I would have known if I was sent an email like this.
So just to clarify, you were sent an email and based off your knowledge about the safety of DRUFA and did not read it as seen by the categories unread?
To clarify, I was never sent this specific email because not only does it not appear in Lush's database for emails, but we did turn our email system over to the plaintiff's side. And I do not believe that you have found anything.
Okay, so just to clarify, yes or no, did you see this email prior to the investigation of your computer systems?
No.
So it is your position today that you have not seen this email?
Today, I may have seen it in court if it was brought up earlier. My mind's a little fuzzy. I'm a bit old.
My apologies. Is it true you've received other reports like this, such as emails?
This would be the only one of its kind if it were to been sent to us.
Okay. Is it true that this email could have been sent to you and you did not read it?
I do not know because I have no personal recollection of it. And like I've stated before, our email system has no recollection of it.
Okay. I'll move on. Let's talk a little bit more about your company's research on the safety of DRUFA. You have stated in your statement that there was little to no risk to persons using your fertilizer, correct?
Yes.
Is it true, based off your previous answer, that there is some risk involved in using DRUFA?
Yes, there is some risk, like with any other product on the market.
Let's talk a little bit about the testing done on your product. You do not bake any of your products, correct?
No, we do not.
Is it true you do not bake your products because it's too—
Objection, Your Honor, lack of foundation. For the sake of the jury and clarification here, I think it would be helpful if we understood what baking is and the benefits of baking to understand Ms. Hollebeck's questioning.
Ms. Hollebeck?
Of course. Would you like me to ask another question to lay that
No,
down?
I would like you to respond to the objection.
Okay. I do believe that Ms. Doncourt would know what baking is, considering she's part of her company. And it was brought up earlier today what baking is based on past witnesses.
Your Honor, if I may respond one last time.
Yes.
I'm not objecting on the grounds of personal knowledge. This is not a 602 objection. We have not heard the foundation laid during this witness's testimony to know what baking is, the benefits of it, or why Ms. Doncourt would even know either of these things. And thus it is lack of foundation.
Well, I think that Ms. Hollebeck is correct that there was testimony earlier in this trial regarding baking and the benefits of baking and the purpose of baking. And I think we can assume that the jury accumulates knowledge as it goes along. And there's no need to lay a foundation with each witness as to what baking is. I think it is likely that this witness knows whether the product that she produces and oversees production of is baked or is not baked, and that is the only question that was asked of her, whether her company bakes its products. So I think the question is all right, and the objection is overruled. Ms. Hollebeck, go ahead.
Is it true you do not bake your product because, as you stated in your statement, it's too costly?
Yes, it is quite costly.
Your Honor, let the record reflect that my co-counsel is sharing on their screen a copy of what has been pre-marked as Exhibit 8.
Okay.
Would you please identify the document on the screen?
It is the amortization table that I created around 2004.
Does this show the cost of baking and versus not baking your products based off of your company's yearly income?
It appears to be the copy that I made, yes.
Is it true and accurate to the best of your knowledge?
I believe so.
Your Honor, at this time, I move for the admission of Exhibit 8. Its authenticity has been stipulated to and its accuracy shown.
Ms. Miller, is there an objection to the admission of Exhibit 8?
There is no objection, Your Honor.
Then Exhibit 8 is admitted.
Ms. Doncourt, this exhibit shows a 6% and 2% increase in profit if you do not bake your fertilizers, correct?
Yes, that is correct.
Is it true that in 2004 only cost $250,000 to bake your fertilizers?
Yes.
Is it also true that in 2004 your income profit was $1,657,000?
Yes, that appears to be so.
Would you agree with me that's a fairly large pay gap?
Yes, but when you put all the costs of all the packaging and the production, everything, and paying our workers a fair and really good wage, it turns out to be a small drop in the bucket.
Okay. And this money that you did, sorry, a little bit of a change of direction here. You have shareholders in your company, correct?
Yes.
And you have to pay your shareholders?
Of course, like any other company who has shareholders.
And you're a shareholder in your company, correct?
Yes.
So actually part of this money that you did not spend goes towards your shareholders and yourself, correct?
Yes, that would happen.
No further questions, Your Honor.
All right, thank you. Ms. Miller, do you have any redirect within the scope of the cross?
I do, Your Honor. But before I proceed, I would ask for a time check from our timekeepers.
Good idea.
I have 1 minute and 43 seconds, Your Honor.
We have 151 from the other timekeeper, so why don't we split the difference?
So what number would you want, Your Honor?
145.
Okay, I am ready to go, Your Honor.
Okay.
Go ahead.
Okay, thank you. I'll quickly ask my co-counsel to screen share Exhibit 4. And while they are doing that, Ms. Doncourt, had you ever seen this email prior to today?
No, I had not.
And was this specific exhibit provided to your attorneys by you?
No, I do not believe so.
Okay, and do you have any recollection of ever receiving this email?
I have no personal recollection.
Okay, and does your company have any record of ever receiving this email?
No, and like I explained on Cross, we scoured our email system here at Lush, found nothing. And then we proceeded to turn it over to the plaintiffs. And so far, I know they have nothing.
Okay, do you know of, moving directions here to baking a little bit, do you know of any benefits to baking other than to bake out any potential risks?
No, I know of no other benefits.
Okay, and I think it got a little lost in the conversation that you were having with Ms. Hollbeck on Cross. Will you explain to me all of the reasons why you decided to not bake your product Drufo?
Well, what went into the decision of not baking Drufo was, as she discussed, there is a cost to it, but our main focus for making this decision was because not only did our studies show that it was not needed and that there was no proof of risk like a carcinogen or a big harm, but we cared about the environment, and that is the main, well, one of the biggest.
Your Honor.
All right, thank you. The witness, I think, completed her statement and she is excused. Would you please remove the exhibit? Thank you. All right, Holly, thank you.
I'm ready, Your Honor.
Thank you.
Ready, Your Honor.
Thank you. All right, we are going to move directly. I'm going to deem the defendants have rested. We're going to move directly to closing arguments. I have 3:47 on my screen, which puts it pretty tight, but let's get going. Plaintiff, your closing argument.
Your Honor, before I begin, I'd like to reserve any remaining time I have for a rebuttal.
That is granted. Go ahead.
Your Honor, opposing counsel, and members of the jury, how much is one life worth? The defendant, Lush Fertilizer Incorporated, and their representative, Blake Doncourt, created the product known as Drufo. This dangerous product caused the plaintiff, Dakota Wares, to get the chronic illness known as non-Hodgkin's lymphoma. So I ask, how much is one life worth? Earlier today, my co-counsel presented evidence regarding the multiple tests done on the product Drufo. I would like to explain these tests a bit further and specifically examine the results of these tests, and more importantly, what they mean. Simply put, Carson Durst found conclusive evidence that Drufo could cause cancer in rats and could potentially cause cancer in humans. Additionally, Dr. Casey Rogers found a correlation between Drufo and cancer and stated that Dakota Ware's symptoms were consistent with the ones found in her study. As you have heard, both witnesses found correlations between Drufo, cancer, and specifically non-Hodgkin's lymphoma. And yet, Lush Fertilizer paid no attention to it. However, these are not the only facts that prove Lush Fertilizer's negligence. Skylar Wares, the defendant's own witness, stated that Drufo, by definition, is a poison. This was backed by the testimony of Dr. Devin Williams, who stated that not only is Drufo banned in the EU, but Drufo contains nitrogen, which is a known carcinogen. If the defendant doesn't even listen to its own company's concerns about a product, then why would they be concerned about the safety of their customers? Based on jury instruction number 3, the defendant did not exercise reasonable care. Blake Doncourt wanted to wait till he was 100% sure Drufo could cause cancer before he would spend money to make his product safe. He blatantly stated that the reason her company does not bake its products is because it's too costly. And let me remind you that baking their products would remove any question on whether Drufo is carcinogenic. On top of this, Ms. Doncourt was banking on the success of Drufo to build her company in its early years, which resulted in multiple cut corners. It was Lush Fertilizer and Blake Downcourt who put the price tag on Dakota Ware's life. Members of the jury, the burden on the plaintiff to prove that the defendant, 1, manufactured a fertilizer product containing the chemical compound known as Drufo. 2, was negligent by failing to exercise reasonable care to prevent an unreasonable risk of harm to persons who have been reasonably expected to use the product in a manner the defendant should have reasonably expected. 3, the plaintiff was one of those persons the defendant should have reasonably expected to use the product. And 4, the plaintiff had damages that were caused by the defendant's negligence while the product was being used in a manner the defendant should have reasonably expected. We have done this. Blake Downcourt has already testified to the fact that her company created the product known as Drufo. Her company decided not to bake their product, put any warning labels on their packaging, and purposefully hid and ignored the dangers of Drufo. As for contact, Dakota Wares continuously encountered Drufo during her time at Haven Landscaping, which resulted with her getting non-Hodgkin's lymphoma, which now prevents her from taking her full ride scholarship to Juilliard and causes members of the jury. It was the defendant's product who did not put a warning label on their packaging, the defendant's product that was not baked properly. It was also the defendant's product whose testing results came back inconclusive, resulting in a second study, and so much more. So I ask you, how much is Dakota Ware's life worth to you? Please return a verdict finding the defendant negligent. Thank you.
All right, thank you. Timekeeper, what time is remaining?
1 minute and 7 seconds.
Okay, 1:17. Defendant, please make your closing argument.
Thank you, Your Honor. Members of the jury, today we have heard the case of Dakota Wares versus Lush Fertilizer and have been called to determine, based off of proof, not possibilities, whether the defendant Lush Fertilizer is negligent in the claims brought against them by the plaintiff Dakota Wares. Today, we heard testimony from 6 witnesses, and through the testimony of each of those witnesses, we saw that while the plaintiff only provided us with vague, inconclusive possibilities, the defendant and the defense has provided us with clear, conclusive, indisputable proof. We first heard from Dr. Casey Rogers. Casey Rogers shared with us a study which is inconclusive as it failed to consider all environmental factors Dakota was exposed to while on the job, meaning that any findings of this study only show possibilities related to Dakota's condition. I'll also remind you that Dr. Casey Rogers couldn't even remember the contents of their own study, let alone that they wrote a prior witness statement at raising the question, how much can we truly trust their research? We also heard from Carson Durst. Carson Durst, who explained to us a study that their entire testimony was based around. This study was conducted by a lab in England and only showed that Drufo was potentially carcinogenic. This study and Carson Durst's testimony show no proof, but only possibilities, and are a clear example of the plaintiff attempting to use possibilities rather than proof to form their case here today. We also heard from Dakota Wares themselves. Dakota Wares, who explained to us that they don't have any idea what caused their cancer and said, quote, "It's only my belief." Words like my belief, no idea, I think, maybe, possibly, could, are words that in her opening statement, my co-counsel, Miss Bono, asked you to listen for. And Dakota Wares saying that she only thinks that Lush Fertilizer caused her cancer is a clear example, once again, of the plaintiff attempting to use possibilities, but no proof, to form their claims here today. We also heard from Dakota that they failed to wear proper PPE and protective equipment recommended by both their boss and Lush Fertilizer, simply because it was too inconvenient and too much of a hassle for them at the time. We also heard from Dr. Devin Williams. Devin Williams, who explained to us that Lush Fertilizer spent 7 years studying the safety of Drufo, a clear example of proof that Lush Fertilizer has taken ample time to guarantee the safety of Drufo for the sake of their customers. We also heard from Skylar Weirs, who explained to us that Dakota used many different products during their time at Havens Landscaping, meaning that there is no causal link between any of these products, including that of Lush and Dakota's condition. We also heard from Blake Doncourt, who explained to us the proof behind each of the decisions made around Drufo within her company, Lush Fertilizer. Ladies and gentlemen, I'll now redirect your attention to jury instruction number 2, which outlines the burden of proof that the plaintiff must meet here today in order to prove the defendant negligent. We see in this jury instruction that they must prove each of these 4 elements in order to meet their burden of proof here today, but that they have failed to prove 2 and 4. We see in element number 2 within this jury instruction that the defendant took reasonable care, as was explained to us by Devin and Blake, and that the product was not used in a manner which should have been expected, as was explained to us by Dakota, as she did not wear proper PPE. This once again applies in element 4, but we also see that there is no proof that the plaintiff has damages which were caused by the defendant's negligence, as there is no causal link between the use of Drufo and Dakota's diagnosis. The plaintiff has failed to prove these 2 elements, meaning they have failed to meet their burden of proof here today. Ladies and gentlemen, it is clear that through proof, not possibilities, that the only plausible conclusion to be considered here today is that of Lush Fertilizer being found not negligent on all accounts. Thank you.
Thank you. Plaintiff, you have 1:17. So please get going.
Thank you, Your Honor. Today, the opposing counsel is trying to convince you of proof, not possibilities, that all the plaintiff has provided is possibilities. Let me remind you that it was actually Lush Fertilizer whose testing results also came back inconclusive. And the only reason Dr. Casey Rogers' study came back inconclusive was because of lack of time. As for proof, we have proved time and time again that Lush Fertilizer purposefully puts money, greed, and above the safety of their customers. They want to keep all the hidden dangers of Drufo within their walls because they don't want to spend money to make their product safe. It was Lush Fertilizer who put the price tag on Dakota's Wear's life, and we have proven this again and again today. Lush Fertilizer is merely trying to convince you that another company can take advantage of you. They take advantage of you through greed and money and don't let you know of dangers. Thank you.
Thank you. The case stands submitted. Now, please, the scoring judges need to complete their scorecards. Make sure that you have your phone number on the scorecards and push submit when you are done. Would the court monitor tell me when she has all of the scorecards and has submitted them?
I sure will. They have all the score sheets.
All right, thank you. Since this is the last round, we're not going to go through feedback unless the people would like it. I'd just like to say that this was a very good presentation. And I think one of the sad things about doing this by Zoom and having a virtual meeting instead of meeting in a courtroom is that you don't have, the participants don't have the opportunity to share feedback or at least appreciation from a gallery and from the judges, including me. So in lieu of that, I want to say that you did a very good job. I appreciate it. I hope you enjoyed participating in this competition. I'm not going to release the scoring judges until we've heard that the scorecards are approved by the command office. But for the rest of you, thank you very much and enjoy the rest of your weekend.
I just want to make sure that you know that they said that they have everything and we're done.
We're done. Okay,
Yep.
thank you very much.